There's Andy. Hey. We had your phone call the other day. And we have somebody back from the job. Did already also.
Hi, Tom Burns. Hey, John. Welcome. Thank you very much. Thank you. Hi, I'm John.
We're already 14, 10 pages. So narrowed scope. With more time, you probably get more.
Sometimes it's.
Wonderful. Can I confirm that we have Representative Buckley on the phone?
I know it probably didn't give you enough time to read all of this stuff. So that's what the draft is all about.
I know.
Had a draft.
I know, but that's what this piece of paper is.
Yeah.
We're just waiting for it to start.
It really starts off. You tried 3 times, and I am a kid.
J-O-H-N. I just want to make sure I get it right the second time.
I'm a good company then.
Oh, yes. Yes, I apologize. Yeah.
Yeah, mine did Roger quite a bit.
Okay. Teresa. Toby Ryan. Well, good morning, everybody. Welcome to the Rules Advisory Committee on House Bill 3460, the Medical Marijuana Dispensary Bill. I'm Tom Burns. I am not the chair of this group. There won't be a chair. I'm simply a facilitator to help these people sitting around this table come up with rules to implement this bill. I want to apologize first to a number of people. I am a fairly decent facilitator. I am a fairly good politician. I'm a fairly good organizer, but apparently I'm a terrible speller. And so I apologize to the people around the table whose names were spelled wrong. Some of you have tried 3 times to correct me. I still don't get it right. So, you know, if you see other misspellings, I'm sorry, I can't spell. I'm a product of the California public school system. We have been charged with coming up with rules to implement House Bill 3460. The Health Authority put together this group to do that. This is an advisory committee. This is a group that tried to be representative of the community who's going to be impacted by this bill. And it is a group that you all can feel free to reach out to, talk to, participate with. We will have public comments at the meeting so that you can bring up issues that we failed to bring up. But it is your opportunity to help this group work. In order to do that, I think you need to know who these people are. And so you've seen some of it, but I'm going to start over here with Paul and work around the room. One rule. The microphones are directional, which means that, Anthony, you will be picked up every time. Paul, you may be. Jack, so you're going to, if you could move the microphones around, it would be helpful. If you'd be more comfortable to take them off the stands, feel free to do that. But, you know, they are fairly limited, unfortunately. Oh, and the other thing is we are streaming live, so make sure your hair is in place because your mom's watching.
And Channel 23.
Okay, Channel 23 up there. Yeah.
All right, thank you, Tom. My name is Paul Schmidt. I'm a retired law enforcement official. My career started with the Sheriff's Office in Colorado, DEA for 22 plus years, retired from DEA, went back to the state of Colorado, joined up with the Department of Revenue, and headed up the Medical Marijuana Enforcement Division in Colorado. Left there and came back here where my wife and I, and we reside in Camden, Oregon.
My name is Anthony Johnson. I'm the Director of National Cannabis Coalition and New Approach Oregon. I've worked with prospective medical marijuana facility operators, medical marijuana clinics, and I really look forward to working to put together a law that works well for patients, the community, and all stakeholders.
Jack Crabtree, Sheriff of Yamhill County, and I'm here to represent public safety and specifically the Oregon State Sheriff's Association.
I'm Rob Ovett. I'm the District Attorney from Lincoln County. I've worked in the drug policy arena in Oregon for a couple of decades and worked with Jeff and others on House Bill 3460 and look forward to getting rules that make this fly right.
Hi, Andy Olson. I'm state representative from the Albany area. I'm in my 5th term and served 29 years with the Oregon State Police before that. Looking forward to do this. And just to point out, Tom, push-ups are acceptable.
Yes, sir.
Hi, my name is Jeff Sugarman. I am here representing Oregonians for Medical Rights. I think Senator Przansky and I are the only two on the committee who were around for the original drafting of the original Oregon Medical Marijuana Act in 1998, and we both served on the work group in 1999 that did the statutory rules and regulations. The one thing I can say is this is a lot fancier room than the small conference room on the 4th floor of the Capitol that we worked many hours in during that time. But that group was much like this one, and we worked very collaboratively together to draft some good rules and regulations with the idea of patient access and patient safety in mind. And I'm looking forward to working with all of you on the process this time too. Thank you.
Todd Bellato. I chair the Oregon Health Authority's Advisory Committee on Medical Marijuana. We're a statutorily created ongoing advisory committee that advises the director of the Oregon Health Authority on the administrative aspects of the program, as well as we'll be reviewing and advising on these proposed rules as well. I'm also a horticultural scientist, president of CAN Research, Education and Consulting in Corvallis. I provide professional consulting services for the cannabis industry, as well as carrying out horticultural science in Corvallis, Oregon. I've served on several of these rules advisory committees and legislative advisory committees, but none with the broad scope of what's before us here today. And we've often had a much longer time to promulgate rules of much narrower scope. So I'm excited to be working with this committee to get started.
Thanks, John. Hi, my name is John Sassman, and I am the Chief of Police in the city of Corvallis. Todd and I know each other, and I'm looking forward to this process. I also represent the Oregon Associations of Chiefs of Police. Thank you.
Noel Bullock. I'm a former state employee responsible for disposition of excess and surplus property, including evidentiary property from most intergovernmental agencies that cooperated with DAS. I now am in private practice, and I'm the executive director of Cherry City Compassion, a registered nonprofit, and I'm here to represent dispensary owners in the new Oregon landscape.
Hello, I'm Corey Brzezinski, State Senator District 4, which includes parts of Lane and Douglas counties. I chair the Senate Judiciary Committee, and just to verify what Jeff was saying, I have the gray hair to show that the age of how long this has been going on.
My name's Amy Margolis, and I'm a criminal defense attorney. I've been representing people on cannabis-related charges for more than a decade now. I've also lobbied for Oregon Criminal Defense Lawyers Association and Partnership for Safety and Justice, although I don't represent either of those organizations here today.
My name is Gary Schnabel. I am a pharmacist, and I'm executive director of the State Board of Pharmacy. I've been there for 19 years, and I've been peripherally involved with these marijuana discussions for almost that long. Not directly involved in a lot of it, representing the Board of Pharmacy. We're sort of on the side watching that, but there are, the world seems to revolve around drugs, and it seems to come through our office in one way or another. So I'm excited to be here as part of the group.
Brings us up. Representative Buckley, are you on the line?
Yes, I am.
Oh, do you want to do a quick introduction?
Sure. I represent Peter Buckley from Ashland, represent South Jackson County in the legislature, and I'm the co-sponsor of this legislation with Senator Brzezinski.
Great. Okay, thanks to all. I thought I'd do a couple things here. First of all, there's been a number of questions about where the authority for medical marijuana dispensaries is going to live. I need to make it very clear that decision has not been made. We don't know. It will be somewhere within the Oregon Health Authority. There is the medical marijuana program, which does the approval and certification of the cards. That exists. There are other organizations. There is a health licensing agency that licenses hospitals. That's another organization. I run the pharmacy program. To the extent that it's pharmacy, there are a number of places, but that decision hasn't been made, and that will become important as you look at the rules, because we're going to need to make sure that we write something that is self-contained. Secondly, I want to make sure that everybody understands there's a number of areas here where we simply don't know what to do. And so we're going to spin off a couple subcommittees, and I'll talk to you a little more about that. But those of you in the audience who are here on those subjects, I didn't want you to panic that we've forgotten you. We simply don't know what to do. I also need to remind everybody that I at least work for the executive office. Yeah, Rep. Buckley, can you mute?
I am on mute.
Okay, anybody, anyone who's on the phone, if you make sure you mute because you feed back in here. Because I work for the executive office, I have to follow the lead of the governor, and I just want to remind everybody what the 2 charges for the governor were for this RAC committee. We want to ensure the overall safety of our communities through appropriate rules to license and regulate dispensaries. That's the first one, safety in the community. And second, we want to allow patients safe access to marijuana if they are eligible for treatment. So those are the 2 charges that we've been asked to function under. The other thing is we need to talk a little bit about timelines so that the committee has a sense. I've sent you some stuff out, but I think it's important we look at this. The law goes into effect March 1st. On March 1st, the Oregon Health Authority has to start accepting applications and approving those applications for dispensaries. We had an option. We could put the rules in place on March 1st and people could start read the rules as fast as they can and start sending in applications the day after that. I'm concerned about that, so I have tentatively pushed the date for this Rules Advisory Committee to have its rules published to February 1st. That gives the community 28 days, I guess February has, to review the rules, get their applications completed, and submit the application starting on March 1st. If we're going to meet that February 1st deadline, this committee needs to be done for reasons that I don't understand by about, we have to submit the rules for publication by December 15th, which means in order for us to go through our internal process and that, we need to be done by December 1st. So that's counting backwards. So we really only have the months of October and November to get our job done. I think it's important that we meet often. I don't know how often that is. That's going to be your call. We can obviously do teleconferences if getting people together doesn't work. I have tentatively set up a couple dates for reserving this room, and I'm looking to Teresa for those dates. They are 2 Fridays. She'll get those to me before we go too much longer. But one in mid-October and one in mid-November for in-person meetings. Again, if you decide you prefer a teleconference, we can do that. But it makes it easier for the audience to participate if we do that in person. We can meet more often, and we may need to send off some subcommittees. And so because of the interest of timing of one person who I need to introduce to you, I want to jump into subcommittees unless someone wants to raise an issue about timing the process or any concerns about that. Okay. One of the areas that this bill calls out is for testing of pesticides, mold, and mildew. Now, I know how pills are made. I know the process by which prescription drugs are done. I know what I spray in my garden and on my tomatoes, and there aren't any pesticides in that I'm aware of. Anything that looks moldy to me, I throw away, but I have no idea in this business what it is those terms mean. So Dr. Goldberg reached out to the State Department of Agriculture to ask for help because they currently approve pesticide standards for the food that is consumed in the state. So Ted Blanchard and Dale, whose last name I've lost, Mitchell, are sitting over here in the corner. I was going to ask them to go off and craft this stuff. And I know that Todd, you have a background in this. I know that, John, where are you? And is Peter Marshall here? Okay, Peter Marshall was in the... Patrick, I'm sorry, Patrick. See, I'm terrible with names. You also go by Don somehow. Don't go there. I would like them to sort of go off and craft this. Now, if anybody wants to be active participants, I would encourage that, but I sense that this is such a unique and difficult subject that I, at least the one, have no background to guide on, would be an idea. Senator, anyone to grab the mic?
I think the only thing I would like to be able to do is have input at the beginning, and I think that would be maybe having the members who want to have perspectives considered, such as for myself. I really think that we should be looking at organics in the sense of how production takes place. It seems to be the most safest way to ensure that the patient is not getting anything. So to me, that's a standard that I'd like to see move forward. And so I'm sure others have thoughts, but I think that would be good. Understand that certified smart people are going to be able to take this forward for us. but I think it's important for the commissioners, committee members to actually be able to express some of the goals and intent that we should be striving for.
Okay, well, I know Ted's going to keep notes, and we'll be sending out a distribution list for involvement, and I will make sure that everybody, that we post this stuff on the webpage so that anybody else wants to participate can be there. I have no idea what organic means.
Non-use of pesticides.
And is that measurable?
Yes.
Okay.
I called a grower that I know before I came here, and I don't know, I'm sure there are plenty of growers in this room, but who maybe would or would not admit to doing that. But maybe it would be helpful, since a lot of people don't know really the process for how marijuana is grown, if we have maybe a short, even if it's just a video tutorial about what goes into growing marijuana. I mean, a lot of people use pesticides, and a lot of people, we have particular issues in the Northwest that maybe require that. Some people are better or worse. Some of those don't leave residue. Maybe it would be helpful to even just have a short summary of what goes into that, so when we look at those suggestions, we understand what that process is.
Can you bring something back to the next meeting, or get something put together to be distributed?
Absolutely, I'm happy to have that happen. I'm happy to have somebody put together a short explanation for how that works, so I'm happy to have that happen.
So, any other discussion around testing? Again, I think, if get hold of Ted, whose name, can I post it on the webpage?
Sure.
If not, you can work through me and I'll send it to you, however you want to do this. So that's testing. The other one is the subject of security. And again, the law says that the security must include a video surveillance system, alarm system, and safe. I have no idea. And again, people around the table, if you want to weigh in on this and keep this here, that's fine. But again, I thought that if we could find some people outside who are experts in that subject area, that it may pay us to have them go off and look at things. I know I looked at the Colorado rules, and they get down to the number of pixels that each camera has to use, and the exact location of each camera, and how long the security tapes need to be held, and how secure the whole building is. I have no idea. And so that's an area that we're going to have to wrestle with. But again, I thought if we could find some experts to go and work on that and bring that back to the next meeting, that would be an ideal way to address that.
He's not going to say anything, so I will. I think Gary ought to be involved with that, because, we have at least an operating model in Oregon in relation to pharmacies. So pharmacies are required by both federal and state rules to have security systems in place for controlled substances and a variety of things. So I don't know to the extent that's applicable, but at least we know how it works in the pharmacy setting. So I don't mean to volunteer you, Gary, but I guess that's what I'm doing.
Thanks, Rob. I'm usually a pretty shy guy, but with the microphone this close, I better say something. And Rob's right. We have standards for security, and I may be able to come up with an expert or two in security systems that could help us work through it.
So you want to take that on and be sort of the subcommittee chair?
That's what I get for taking the microphone.
And Tom, I think the one thing I heard you say was that gave me the impression that maybe people think that this would all be produced inside, indoors. I think that we need to have an option for both indoor and outdoor.
Yeah, just hand it around. And I don't mean to dominate it on this side of the table, so kick me if you want to talk. I try not to talk, but I sometimes get going away. Okay, so that's sort of the preliminaries here. I did think it would be important for the members, and I will introduce one other person. Shannon O'Fallon is the attorney for the medical marijuana program from the Department of Justice, and will be advising us on this process as we go through this. And she's also the author, preliminary author of the first draft of rules. So I thought it might be helpful just to hear again sort of what is in this bill, and perhaps therefore what's not in the bill, so that we can have a sense of where it is that we need to go. So Shannon, you wanted, that mic is live up there, and if you want to go through that, and Gary and Senator, you know, if you want, Jeff and Senator, if you want to chime in on your side, that would be good too.
Good morning. I assume that most of you are really familiar with 3460, House Bill 3460, so I'll just go through it pretty quickly and hit sort of the high points. Essentially, it requires the Oregon Health Authority to establish a registration system for what in the bill are called medical marijuana facilities.
Representative Buckley, is that mic that Shannon's speaking from live? We can't tell in-house.
Yeah, I can hear.
Okay, thanks.
So there's a process for that. The main parts of the act do not go into effect until March 1st, 2014, as Tom said. And so a medical marijuana facility is going to be able to receive usable marijuana and immature plants from cardholders, which we might otherwise refer to as patients, from caregivers or from growers, as long as the patient has authorized that transfer to happen. In turn, it will allow a registered facility to transfer usable marijuana and immature plants to a patient or a caregiver. I believe it does not include transferring marijuana back to a grower. So a person responsible for a medical marijuana facility is going to have to fill out an application that the authority is going to prescribe what's going to be on that application. It has to include the name of the person that's responsible for the facility, the address of the facility, and proof that the person responsible for the facility is a resident of Oregon. So there is a residency requirement for that individual. And what it means to be a resident is something that we're going to have to specify in rules. And then the application process will also include any other documentation that the Oregon Health Authority feels like it needs in order to complete the process. In order to be registered as a facility with the authority, you have to be located in an area that meets certain zoning requirements. It has to be zoned either commercial, industrial, or mixed use, or it can be agricultural land. A facility cannot be located at the same address as a medical marijuana grow site. And so we're going to have to figure out sort of how that, there's going to need to be some communication between the Oregon Medical Marijuana Program and this, the part of the authority that's going to deal with this system and figure out how that's going to work. You have to be registered as a business with the Secretary of State, or at least at the time that you apply, have an application pending with the Secretary of State. And you can't be located within 1,000 feet of the real property comprising a public or private elementary, secondary, or career school that's attended primarily by minors. You have to comply with any rules that the authority adopts around
questions as you're going through this.
Sure.
You want us to wait?
No, you can ask.
The career school, that's something I'd like to be able to get a little bit more understanding of what that means. You did give some clarification that primarily attended by minors, but what a career school actually is defined and what we're going to be working, so we know what the parameters are.
Yeah, I mean, I think it's an undefined term in this law, and so I think we're going to have to, first we could look elsewhere in the statutes and see if it's defined someplace. I'm assuming that the provision that talks about a school being attended primarily by minors is really meant to apply to the career school and not primary and secondary schools, because I think that's, elementary schools, middle schools, high schools. But career schools, you could have, might mostly be adults, and so in that case, it wouldn't apply. That's my thinking.
What about a daycare setting? It's silent, but was that a conscious decision, or?
I guess what we did as often as possible in drafting the law was use existing language in the statutes, and so we just modeled it after existing language.
Also, I want to point out that there's licensed private career schools, and you could view those at the Department of Education website.
I don't know if they're public career schools.
When the 1,000 feet of a school talking about protecting minors was drafted in my jurisdiction, I've got a major university, and there are a multitude of daily activities that bring minors onto that campus regularly. And actually, lots of kids who are there who are, middle schoolers and preteen. Was that considered, or are we really looking at the university as they're just simply exempted?
I'm assuming that universities, that the 1,000 foot would not apply to universities, but I can't really speak to legislative intent. But it's certainly not in the plain reading of the rules. I wouldn't think a university would be included.
Okay.
Or a daycare for that matter. Okay. So as I said, the facility will have to comply with any rules the authority has around testing and security. I think one of the things that we're going to have to figure out is, there's a requirement for testing for pesticides, mold, and mildew, but the bill doesn't say anything about what happens if you have marijuana that tests positive for any of those particular things. So I would expect that the rules need to say, what happens if there is such testing? Is it an absolute ban? Is it not? What happens to the marijuana if it tests positive for something, and therefore it can't be further transferred? Does it go back to the patient or whoever transferred it? Is it supposed to be destroyed? So the rules will need to work out those sorts of things. There's annual renewal, and then the rules are going to set the fees for registration. So that will be an initial application fee and a fee that will be due at renewal, at the annual renewal cycle. So those are sort of the new parts of the statute. There are other sort of minor amendments that are made to what is sort of the existing Medical Marijuana Act, ensuring that delivery does not include the transfers of marijuana that's otherwise authorized under the bill. The statute permits law enforcement to have access to information about who the person is responsible for the facility and where the facility is, so they can see whether or not they're legal, things like that. So does anybody have, those are sort of the highlights. The other issues, I think, sort of are more minor. We will, in addition to the rules that you see here, there will need to be probably some slight tweaks to the existing medical marijuana program rules. And I will, Department of Justice, we've had a paralegal that's tried to compile together all the state statutes and rules or local government rules around medical marijuana facilities and what are otherwise considered dispensaries. And it's a huge document, but it may be that that information is useful to this group as you're looking to see if there's existing language that would be good to model for the rules.
Thanks, Shannon. She mentioned something that I forgot, and that's the subject of fees. We do need to set the fees for this. The bill has an an expenditure authorization of $802,000. That came up with by somebody putting together a fiscal note inside OHA and sending that to the legislature and actually having it amended into this bill instead of it simply added to the budget authority on its side. That our fiscal people are looking at that and are aware of it and are trying to figure out whether that's an absolute limitation or not. I don't know whether there's a conscious decision to say if we have more than we anticipated number of facilities that we need to license, whether that expenditure authority can increase or how you want to handle that. That's the problem. Fortunately, it is a 24-month number, and because we won't be going live really until March, there's some savings that can accrue. But there are costs that are already occurring. That's not the least of which is these meetings and drafting the lease. But the fees also have to go through a secondary process, which means we really need to set the fees for sure no later than the November meeting in order to push to the process. So if they keep that in mind as we start building these things, then what do you think it's going to cost OHA to actually go out and do the kind of inspections that this bill calls for. And then we'll have to back in with an estimate of how many facilities there will be and what those, and then divide the two numbers and come up with a fee cost on an annual basis to pay for this. So keep that in the back of your mind. The other thing, Shannon, is you mentioned some land use issues. How much authority do we have in this bill to address land use issues?
Yeah, and there's a couple other provisions that I'll go over as well. So I don't see that the Oregon Health Authority can do anything to affect what local government is going to do with regard to permitting or not permitting these facilities. You know, there were some conversations during the legislative session where folks representing cities or counties believe that in fact those localities could prohibit the facilities from being located there. You know, that's not going to be anything that the Oregon Health Authority has anything to do with. So it sort of raises the questions, are you going to you know, accept an application and accept a fee for a facility that otherwise is prohibited from operating in a locality where it's planning on doing business. So, I don't know what the answer to that is.
Yeah, I mean, you guys are going to make these.
The intent was not to say and prohibit an operation or a business coming into a community, but allowing the community to set parameters of where it would be. The outright say that a community can outright ban would be against what I believe is the intent, because how else are you going to have the ability to have the facilities to provide to the patients if you could basically have a number of communities to say no. But what I thought we were doing, we do have individuals that were working with us from the League of Cities, is that we're giving them the flexibility within the understanding that this was going to be the next step from that marijuana program, was allowing for dispensaries to have better access and control to safety, not only for the community, but also for the patients to be able to get their medicine through that process.
So are you suggesting that perhaps we invite the League of Cities, so I see Scott sitting in the back up there, and I've been contacted by a number of county and city planning commissioners on this subject. Should we send them off to come up with some advice to us on this, or would that be a good way to address this? Okay.
So can I go through a couple other things? Another important process that the authority is going to be going through is doing a criminal background check on the person responsible for the grow site. And so it's not limited to Oregon convictions. So I think it would be a nationwide criminal background check, is my guess. So a person who's been convicted for the manufacture or delivery of a controlled substance in Schedule 1 or 2 cannot be a person responsible for a facility for 5 years from the date of conviction. And then if there's more than one conviction, then it's an outright prohibition. So that's what you see the rule about the criminal background check process.
Excuse me. Can we hold public comments? We're going to have a specific period at the end for public comments, and we'll encourage everybody to make their comments at that time.
Just curious, with respect to the convictions, I saw in the bill that it really limits it to just the convictions for Schedule 1, Schedule 2. So a rapist, anybody else like that who has been convicted can operate in these facilities. And employers, they have to decide if they want that person there. Fair?
Right.
So an employer could decide, if I've been convicted of rape and Noel's my boss, Noel can decide whether or not he wants me, but if I've been convicted for Schedule 1 or Schedule 2, then I'm absolutely prohibited. He can't hire me.
Well, it's only the person responsible for the facility that undergoes the criminal background check. There's no criminal background check requirement for employees.
Okay, so it's specific to the individual.
Right.
And speaking to that as well, I'm aware of many facilities whose director, owner, whatever title you want to put on that, have nothing to do with the day-to-day operations. So the idea of key personnel or management undergoing security checks, it seems like there's a lot of holes in that theory. You could have a straw person set up with a clean record that was run by people that maybe weren't so clean. And you could have a good person that has nothing to do with the day-to-day operations when the staff didn't meet the standards. So I think that needs more thinking.
And if I may speak in with Noel there, from past experience, that was one of the reasons in the other states that led to a lot of problems was they were only doing background investigations on the primary owner or business, and yet not making any requirements to the employees or others associated to the business. And as Noel just explained, that's exactly what you got. You had owners that had no knowledge of what was taking place in their business, day-to-day practices or anything, but simply were there on paper and had no idea. So I think great discussion for the panel to bring up to kind of really tighten that up in the interest of not only patient safety, but public safety also.
And I'm glad that Shannon mentioned it, because it seemed in the side notes and the information that we got that somebody may have been under the impression that it was from the end of the sentence, 5 years from the end of the sentence, but it's 5 years from the end of the conviction, correct?
That's the problem with reading old law as opposed to the final law signed by the governor. I take responsibility for that one.
I think from a procedural perspective, it's a really interesting issue. I'm sitting here listening to what everybody from law enforcement had to contribute. I mean, what that would require, I think, from a fiscal perspective, as well as just how many people you need going through that. I mean, you would have to untangle essentially the entire business to see if you could investigate and figure out who's really behind it. I mean, I know from thinking about how much that might cost, you would need kind of a full-time investigator, somebody to talk to the registered agent or owner, and I think registered agent and owner are two different things. Then that person would need to be willing to disclose to you who their partners are. I don't know how you could require that to happen. Then you would have to try and make sure that those people were being honest about who their actual partners were. I mean, I think it's a kind of sticky wicket once you start that, and how much that costs a program that, you know, will be funded, but is really an interesting problem for people. I mean, I don't know how you actually do that. I think, you know, requiring employee background checks might be one process, but I think trying to untangle a partnership, I don't know if that's interfering with commerce or not, but it certainly is going to pose a huge problem for the agency running this. At least that's my perspective on it.
And my quick comment is I think we have a model that actually works, where we don't actually have to, for example, run the background checks of the board of directors of Walmart. What we do require for someone to get a pharmacy license or a pharmacy technician license is them to apply to the board of pharmacy, and they have to, as part of that, get a background check done. And so I think we can actually do that. We have a model that works in the pharmacy setting, and I think we can do the same thing in relation to these facilities. Yeah, if Floyd and I each own a 20% share of this thing and we're not on site, I mean, we're irrelevant. It's the people that are working there. It's the equivalent of the pharmacist and the equivalent of the pharmacy tech that we want to make sure are clean.
And going along with that, we can ask certain information on the application form about the principles and the type of organization it is, whether it's a corporation or whether it's a school. And we get that at the Board of Pharmacy. We also have a requirement that we're notified for each pharmacy who their principal daily operations person is. We refer to them as the pharmacist in charge. So they don't have any separate background check other than what a normal pharmacist would have. But that's the person who's responsible to the regulatory agency for what's going on day to day. And all we need is that person's name.
I tried to sort of get at this issue in the rules a little bit by attempting to make it clear that the person responsible for the facility has to be the person that's sort of legally responsible for the operations, and they're the ones that have to ensure that the rules are being met. So, I mean, I'm sure that we're going to be further editing those rules, but yeah.
Yeah, also just to comment that, that in the statute, the person responsible for the medical marijuana facility responsibility is only in that word, in that title. So it doesn't really convey much more legal responsibility besides the title. So anyway, I also think we're going to be finding a lot of areas where we're going to be improving this in the 2015 session. So.
That does remind me that we also have a 2014 session, and to the extent that there is something that is really a deal breaker problem, we could always ask our representatives to
I was
address
just
something in 2014.
I was going to say that because I think there's going to be some things, and I was mentioning this to Jeff even before the bill was passed. There's going to be some, I think, there's unavoidable tweaks that we're going to need to make to this bill in February, and that will be before these rules go into effect. This area may be one of them, and I think there's going to be a couple others, and there's at least one other huge one that I'm aware of, and we'll get to that at some point in time as well. So I think there's going to have to be a punch list of things we have to tweak and fix with this bill, and that's just one of them.
Okay. So if the facility meets the requirements that the authority has and the requirements in this statute, the authority is required to register that facility. The facility has to display proof of that registration, and any times that they're sort of open for business. They can receive medical marijuana as long, again, as the patient has authorized that, and there's going to be an authorization form. That's a form that the facility has to keep. The facility has to document any transfers of marijuana. The bill does allow for both the facility to reimburse the person who transferred the marijuana or plants to it for costs related to the growing, et cetera, of that marijuana, and allows the facility to be reimbursed when it transfers usable marijuana or plants to a cardholder. The authority can inspect the premises of the facility and ensure that they are complying with the rules. And we can revoke facility registration for failure to comply with the rules or the statute. There's also a provision that says we can revoke registration if the person responsible for a facility has been sort of ordered by a court to not participate in what the bill says is the medical marijuana program. That again may be sort of a tweak that needs to be made statutorily. It's a little unclear. I mean, the provisions for facility registration are going to be inserted into what is now the Medical Marijuana Act. So it's going to be provisions of 475, 300 to whatever that statutory string is. But this is not going to be the medical marijuana program. It's going to be a program that's separate. Okay. I think now I've hit all the highlights. Any other questions?
Back in July, the ACMM sent a question to you that, as of our last meeting, we hadn't gotten a response yet, but it's regarding the property issue. Patients, in the 2005 legislature, we clarified that the marijuana produced, regardless of who grows it, is the property of the patient. And this bill uses the words transfer. So the question we were asking is, does transfer mean transfer of property, or does it mean transfer, just physically transferring? Because as one way to interpret it, if you don't explicitly say transfer of property rights, then that medicine, after it's been paid for by the facility and paid for by a patient to the facility, it still remains property of the patient until it's destroyed or used. That's one way of interpreting it. The other way of interpreting, of course, is by saying transfer, you mean transfer of property rights to it. So perhaps you can give us some clarification on that.
Not right this minute. Again, I tried to get at that in the rules by saying I think there needs to be a really clear agreement between the facility and the patient who's authorizing the transfer about You know, how much is going to be transferred? What if the patient changes their mind? Does that mean that they get it back? Under what circumstances do they get it back? Do they have to give notice? You know, all those things need to be worked out, you know, I think ideally between the facility and the patient, so that the rules are clear to everyone.
Real quick here, and thank you. We've established that just like in the rest of the Medical Marijuana Act, it's a shall issue situation. If the standards are met, the facility will be registered with the health authority. Then will it also be like the existing program where completion of an application, the sending of the required fees, and checking all the boxes, affirming, swearing, and attesting constitutes an affirmative defense until it's denied, like the existing program?
My sort of off-the-cuff answer to that is that you have to be a registered facility in order to be accepted from the other criminal statutes. And so by merely submitting an application, you are not registered.
And that's a concern that I have, looking through the weeds of this wealth of wonderful stuff and understanding the staffing levels of the proposed program. I think if that's the case, it would severely impact safe access to the 60,000 patients in Oregon. If we have 4 FTEs that are processing maybe 100 applications in the first week, how many months until the last application received on the first Friday would get their registration approved? So I think that's something we need to revisit.
In saying, just with Noel, one of the crux, I think, to all of our work and everything that's gone forward and everybody's efforts is if the program is not properly funded, it'll fail. And it's that simple. The funding has to be established to support all the rules and regulations put into place for compliance, not only for the patients, but for the public safety. And again, let's not beat around the bush. It all comes back to funding. And if the funding's not there, Noel hit the nail on the head, is when these applications hit and you have 2 state employees going, how many applications? And we've got to go through what? And do background checks and if we don't have an automated system, if we don't have things in place to handle that, it's doomed for failure. And I can say in other programs, after doing audits and looking back on what's been done, the key crux to failure on programs is the funding issue.
I think your point is very well taken, and I just wrote a note about what will we do on March 1st when we have 100 applications show up and need to go through all the processes. There are, I mean, obviously having 4 FTE is different than having 4 staff, and we could bring other staff in to work on this on a temporary basis, but it is a very good point, and we're going to have to figure that out and get back to you on what we're going to do about that.
Just as a side note, I'm thinking of every city that has land use issues, application issues, how you set up business license issues. All of that at some point is going to fold into the process. So much like what you're saying. I mean, I don't think at some point that you have the health authority, but you're going to have local government saying there's a land use issue here, there has to be business license issues here, you have to have compliance, and they're going to have FTE, and they're going to have volumes
It's
of
not unlike a
work.
bar, you know, getting an OLCC license. I think there's some parallels there. That
There's a lot of that,
maybe
yeah.
not reinvent all the wheels.
Okay, so that's the law. Don't go away. Yeah, are there more questions? I'm sorry, are there more questions about the law? So we haven't, and again,
Tom. I guess I'm trying to get a handle on this a little bit and trying to get into being a facilitator with the facility itself or the dispensary. If I have some individuals who are card holders that are wanting to transfer what they have grown from 6 mature plants to me to be the custodial of it and then to use that properly, do I have to maintain that and keep track specifically of that product? And then if, in fact, the card holder comes back and requests to have that back, I see this as being a real mess to some degree to have to kind of keep track, because that becomes a burdensome, fierce on the individual who's trying to be the dispensary. So I'm just kind of curious if anybody has thought that one through.
I think in fairness, again, from other experiences, for the dispensary owner or shop owner, it's like a regular business. And I think Todd brought up a super point. When a patient gives up their plants to a dispensary or to a shop, does the shop actually own them? And in fairness to a shop and a business, they have to have some type of right of ownership over those plants. Even as patients, if I'm a patient and I have 6 plants of various sativas, indicas, whatever, and I give them up to Todd, excuse me for using you as my shop, but I give them up to Todd, in other models, in 3 months from now, what was really helping me with my nausea or my eating disability or whatever my problems were, might not be the same product I'm finding is dealing much better. And what a nice way to go to Todd, where my original 6 plants weren't what I wanted, but he did have in inventory something that would help me at that time. So to answer that question, I think there, as a rules committee, we really need to establish that when a patient does give up the right to the plants and they become part of the shop or dispensary, they are responsible, they maintain them, they harvest them, and they take them through fruition to a finished product for distribution. And coming back with that, it would be a nightmare if my plants had my name on them and I give them to Todd and all at once a mite infestation or a power failure happens and a catastrophe, which does happen, and my 6 plants die. Where's Todd at as a businessman? And where am I at for my product? So I think there really does have to be a clear and distinguished way that as a patient and card holder, when I turn over my rights to my plants and I give them to a person, that those plants are now in their care, in their custody, and their property.
I think one thing that I've had a lot of people come in and talk about is where this leaves the grower. And I think that that's not very thoroughly dealt with in 3460, and I think maybe that's part of the crux of this issue. I mean, I think it puts the patient and it puts the business owner in a difficult spot, but I think it puts the grower in a very difficult spot. You have enough changes in this bill, now you have a dispensary, you can have over their amounts, but those amounts are coming from someone. And I mean, usually it's not the plant that's being transferred, it's, you know, the finished product, someone's walking in with their backpack and they're distributing it to a dispensary. I mean, if we're being honest about what this looks like, that is typically what's happening. And you have a grower who is, because of the way I think this looks like it might function, who is really still in sort of another world. I mean, there aren't record-keeping requirements for growers. There aren't the same kind of very clear avenues for making rules. So you put, I think, the grower, especially in this scenario, which I think is a really good one, who is ultimately responsible? If the grower is responsible to the patient at sort of ground level, you know, who has that power once it goes over to Todd, who's apparently a dispensary owner in this? So I do think it's a really good question. I do think, and maybe it's for 2014, but there are a lot of issues with how the grower functions in this new dispensary world, and I think that's just one of them.
Yeah, and just as was touched on about, you know, revenue and proper funding being necessary, we also need to keep in mind that the industry has to work and the rules have to work for individual patients and growers as well. And I think it's important to give medical marijuana facility operators the flexibility to craft their own agreements. It may work for some to purchase medicine outright. It may work for others to utilize, you know, consignment basis. But I think so long as the tracking and the rules and regulations are put in place, we can properly give facility owners, growers, patients the flexibility to work out their own arrangements that work in the industry.
First of all, I mean, I want to, thank, Jeff and the legislators for getting this bill passed. It's a great starting point. And as Amy pointed out, there's some lacking in regulating production facilities, lack in regulating processing, and even maybe licensing or regulating labs and such. If we had a crystal ball right here, I could see us in a session pretty soon regulating licensed producers, because we are talking about medicinal grade cannabis for people with very chemical sensitivities and high level medical needs and such. So just keep that in mind that currently we're regulating the transfer of marijuana that was produced for a patient under the current system that could be in someone's home, someone's backyard, or a warehouse, and that's going to present a lot of difficulties in what we have right here. But I hope we can also look forward to having a more comprehensively regulated system in the future.
Well, as much as we might want to, we are sort of limited by what the law says in front of us, and that's what we have to focus on. So I think your points are all very well taken, and to the extent that we can potentially push a little bit, that's probably okay. I'm going to let Jen tell us when we've gone too far. She can argue with the representatives. But, at some point, we may have to, as Rob says, put a punch list together of law changes that need to be done. So if that's the bill, it may pay us now to sort of start looking at the rules and specifics, because there's 10 pages of them in front of us and lots of comments, lots of concerns. Yeah. So I just want to, again, the way these were drafted, so that you know what's in front of you, is it's a bunch of X's, XXX-XXX-AAAA. That was done because we don't, the first 6 X's have something to do with where the rules are housed, and that's immaterial to this conversation. We are going to focus on the letters. And so it's A, B, B, and again, there happen to be 4 numbers in that, so that's why it's multiplied, that's why you see it's done that way. So as we talk about this, look at it by, reference the alphabetical number, that we're talking about. And again, this was a 1-week effort on Shannon's part, while on vacation, I think, to come up with this. No, she said not, but it was pretty close. To come up with this. It's then, I looked at it and had another staff person look at it. That's what the comments are reflected on here. No word on this page is sacrosanct. It's your words. You come up with it. You get to decide or recommend what it is the words ought to look like. So with that, Shannon, do you want to, either, I leave it to me. Do you want to start at the top and go through? Do you want to, maybe it would be more productive to ask this question. What's not identified in here that should be? Maybe that's a better way to do it, because we've got all these things. Is there any glaring error, and not error, omission? Is there anything that clearly is missing? Because we're going to spend a lot of time rewriting these as we go through this, and that may help us focus on what's here. And while we're looking at it, or the other option is, it would be helpful for Shannon just to sort of do a quick, high-level run-through, and then you can take notes of what, as we go through what's missing, and maybe not fall into exactly the words on here, but the policy or the subject areas. Maybe that's a better way to do it.
Sure, I can do that. So this first section that's sort of untitled, again, is just to try to make it clear, sort of to your point, Noel, about when someone's covered by the law and when they're not. And so, again, my reading of the statute is that you have to be a registered facility. You can't get registered until on or after March 1st, 2014. Of course, there's the definition section. To the extent that these are terms that are defined already in the Medical Marijuana Act or in the OMMP rules, I borrowed from those. Since that makes sense, again, these statutes are going to be in the same place as the other medical marijuana program rules. We've got, whether I know the ACMM had some
discussion about using the term dispensary. The law uses the term medical marijuana facility. There's no reason why in rule we couldn't say dispensary means a medical marijuana facility. We use them interchangeably, we could do that. Some of these, like person responsible for a facility, we could figure out a way to shorten that. That might be a little bit more user-friendly for purposes of the rules.
Comment on that. Yeah, also looking at my crystal ball, I think eventually we're going to be licensing production facilities. So perhaps not using the single word facility just for planning for the future.
I guess the other, I think the question was raised whether or not these facilities have to comply with pharmacy laws around dispensing. And as dispensing is defined in the law, dispensing is, handing out of medication that's been lawfully prescribed through an order from a healthcare provider, which is not what happens in the medical marijuana world. So I don't think that these are dispensaries, and I would, maybe be a little concerned if we're calling them dispensaries if people think that they are like pharmacies in that regard, where they're not. But it's a policy call, not a legal call.
Shannon,
Yeah.
I didn't understand what you just said.
What I just said?
Yeah.
So, pharmacies, if they dispense, have to be, I can speak to that, have to be licensed by the Board of Pharmacy. So the question was raised, do these facilities, since they're handing out medication, do they have to be also licensed by the Board of Pharmacy? But if you look at the definition of what it means to dispense, dispensing is not what happens on the medical marijuana side, right? I mean, you get a medical marijuana card because a doctor has written on a form that you have one of the qualifying debilitating medical conditions, and that medical marijuana may mitigate, symptoms or other conditions that you have. It's not an order. It's not a prescription.
See, that's where I'm going to just flat disagree with you, because I think the 475, I got to raise this issue, the 475-125 statute, I'll just read it because it's broader than dispenses. It says, every person who manufactures, delivers, or dispenses any controlled substance within this state, or who proposes to engage in the manufacture, delivery, or dispensing of any controlled substance within the state, must obtain annually a registration issued by the State Board of Pharmacy in accordance with its rules. So unless we do something, which is another one of the things that we need to add to our punch list, I think all of these, whatever we're going to call them, have to be licensed by the Board of Pharmacy as well.
But dispensing is not.
This says delivery. Delivery is broadly defined in ORS Chapter 475.
But delivery is accepted, right? I mean, delivery does not include, if you're a registered facility, delivery does not include the transfer of marijuana to and from a medical marijuana facility.
No, I agree with you there, but 475-125, at least on its face, is pretty clear that every person who does any of these activities, manufactures, delivers, or dispenses any controlled substance, has to get a BOP license.
But Rob, I mean, if you think about how the program's currently working, you can use those terms, I think, for the operation as they occur now. If you have a cardholder who has a caregiver or someone growing, they are delivering back to the patient. So I feel that the intent that when we're moving this forward is just giving another venue to allow for the medicine to be able to be received through giving more certainty, patient safety, etc., as compared to saying that this is now going to be considered a pharmaceutical dispensary. And I think that's one of the reasons we didn't use the term dispensary, and why we use facility was because we didn't want to get it interlocked into establishing a pharmaceutical dispensary model for this particular medicine.
Yeah, and also, Rob, I think further down in that section, there is some language that would allow the Board of Pharmacy to accept a licensure from a different agency, and there's a couple of sections in there that might be applicable to this. I don't have it right in front of me, so I can't read it to you, but I've looked at that before, and those are in there.
Yeah, it just seemed to me that if HB 3461 and 475125, to apply these facilities, it should have spelled that out in the statute itself.
And I guess the point is that they didn't notwithstand 475125, which is, I think, one of the things that needs to be added to our punch list of things to tune up in February. And I'm aware of the exception, Jeff, but the exception basically says the board may waive by rule the requirement for registration of certain manufacturers or dispensers if it finds it inconsistent with the public health and safety. So I think the board actually has to affirmatively take action to exempt, I'll call them dispensaries for lack of a better term, however you want to call them, medical marijuana facilities. The board will have to affirmatively take action to exempt these things from its own licensing requirement, and it has to make some public health and safety findings to do so unless we tweak the 3460. I'm not opposed to doing it.
Well, maybe, I mean, Tom and I may need to talk, and maybe the legal question needs to be asked and answered by DOJ. It's not that clear cut to me, but
It is,
I mean,
it is to me.
Well, you should.
Which is why lawyers always disagree, of course.
So I would appreciate, Rob, if you would send to me then your analysis of why you think that they need to be registered with the Board of Pharmacy. That would be helpful. Okay.
However that turns out, we're not looking for projects.
And I'm not suggesting you were.
It's there in black and white.
It's just another one of the things that has to get fixed.
However this turns out, I think that we may be asking the question about whether we need to put in some labeling requirements or packaging requirements, notwithstanding the registration requirement. And I don't see any of that.
Hold your words, labeling, packaging for a minute. I'm going to go back to this. Is this something that the board might want to weigh in on and just do a blanket exemption? I'm putting you on the spot. But it seems to me that if it did, and did that between now and March 1st, it would remove this issue from the table.
Right, and we do have a board meeting scheduled for October 15, 16, 17. And we could put that on the table there. And I can never guarantee what this board's going to do when they raise their hands to vote. But I have a feeling that they're not looking for more projects.
Why don't you, we'll have an offline and talk about how to get it on your agenda and that's it. And in the meantime, maybe Rob and Shannon and any other lawyer who wants to weigh in on this can weigh in on this conversation.
I guess, I had just one more comment. They have to make a public health and safety finding, though. I think it will be hard for the Board of Pharmacy to do that in a timely manner because they have to go through a full rulemaking process as well, as we know, in the absence of these rules. So how can they say this is in the public health and safety interest when there's not even rules adopted for them to refer to and get it done before your rules go into effect? I don't know that they can do it even if they wanted to, mechanically.
I'll leave it to people smarter than me to address those. I mean, we'll work it out.
Maybe even notwithstanding in February.
That's what I'm thinking is quicker.
Yeah. But I did want to, did I hear you say that one of the things missing in here is the terms packaging and labeling, and that you think that ought to be added? I wanted to, yes, I'm trying to keep notes on things that need to be added in here.
To mirror what Gary said, I know definitely on the medicine and the products as they go from the facilities out to the patients, that for public interest and patient safety is very important. The labeling, definitely not for use for patient only and so forth. And that really needs to be, whether it's just a fixed label on whatever packaging that goes out the door or whatever, but in public interest and safety, definitely we need some labeling and packaging requirements to go along with that.
This is I'm sorry. No, go ahead. I've spent a lot of time thinking about this issue. I couldn't agree more with you. And I think it has to do, and maybe this is an area Todd has a special skill set to deal with, but I think that the transfer between the grower to the lab to the dispensary, that somewhere in that process, that packaging maybe occurs, because you can't have a grower responsible for nitrogen packaging, whatever they're gonna package it in so it's fresh and safe. They're gonna then become, in the most unregulated part of this industry, are they responsible for doing that? Do they do that before it goes to the lab? How much can the lab have on hand? Is the lab then need a dispensary license because they're taking, it's going from grower to lab to dispensary, or is it going to the dispensary first and then to the lab and then back to the dispensary? I think that, I think it's a really interesting question. Well, then who does the packaging? Do you have a lot of labs in this country do the nitrogen packaging, and they label it, and they have special labels that deals with everything from the pesticides to the, level of cannabinoids in there. So what that looks like, and I think that's something I have highlighted in mine that we're missing, since I think that was ultimately the original question this conversation started at, is that the testing part is a really important piece, and that transfer as part of that, and I don't know if maybe you need a special registration for a lab, or if they are a dispensary, if they have more than the legal limits, and who has the ownership in that process? Are they a caregiver? Are they a grower? Are they a dispensary? How are they labeled? Because they are also in
They would, if I may, Amy, I would say they are more in the chain of production and the model of the production of the final product. The product's really not going to the lab to be used by an individual or dispensed or given to an individual. It's really there for testing, and you're right, if it's a certified lab, they're going to have a DEA registrant number for the lab to handle controlled substances and so forth, which brings in, we could sit here for hours and talk about the rules and regulations on that, but simply put, I would say the labeling, again, the interest in our intent is really for the patient and public safety. And I really think that intent for the labeling is at the end of the process when the patient goes to the facility and receives the medicine and comes out. That's the importance of the labeling.
And I think that, and I'm mostly interested from my perspective in protecting sort of an unprotected group in this production process. Is if they're neither of these things, none of these things, we have to find, where do they fall in this, and how do we keep them safe? Because they really are, in exchange for some sort of reimbursement, delivering medicine. So that is a concern I have. I think it's missing from here, and I think it needs to be addressed since we're going to require it.
And I guess I was wondering about labels having a child who has a peanut allergy and all the medibles. Do they have to be labeled, the way you go into a grocery store and read the labels? Just throw that out.
And I just wanted to commend Shannon for doing a great job on putting the backbone together for this that we can fill in. And I think page 7 under QQQ, all of the stuff that we wanted to include about packaging and labeling, we fit right into there. And under transfer of medical marijuana, that's process of transfer. So I just fit right there.
Okay, can we move on?
Yeah.
You'll notice that we have a definition for resident, but we don't say sort of what the residency requirements are, so that's going to need to be looked at. All right, so I'm going to move on to the application section. Again, it's going to be an application that's going to be prescribed by the authority. It's going to have to include all of the information on it. It's going to, of course, include the identification of the person responsible for the facility.
I'm sorry, I guess I missed going over what usable marijuana is all about.
Oh.
And I'm looking at the act itself that was set for, that goes into effect, and I'm reading the definition here on page 2. Of what usable marijuana is in describing that. And I guess I just need to know a little bit further, getting right into it, what this is all about. I mean, the usable marijuana means the dried leaves and flowers of the plant cannabis family and any mixture or preparation thereof. Can you give me some examples of what the intent was?
Representative Olson, that language actually was not new to the passage of this law. The definition of usable marijuana it was defined in previous session. Sorry about that. And so I don't think we changed that at all under House Bill 3460, but it would allow things like medibles or concentrates that have been shown to be very helpful for patients.
Okay. Just a follow-up question then, Jeff. There's been some discussion, I've had a lot of concern from folks regarding Rick Simpson oil, RSO. Is that going to fit into this?
I think that the definition of usable marijuana would include something that would be considered a concentrate, which I think Rick Simpson oil would fall under that definition. Yes.
Okay. Are you in a position to be able to describe what Rick Simpson oil is?
You know, I'm not an expert. Maybe somebody else knows.
Rick Simpson oil is a chemical extract, fairly crude solvent extract, which is basically a concentration of the most usable portions of the cannabis plant, namely the extracted trichomes and other forward cannabinoids. So that's the definition of Rick Simpson oil, and there are several other types of concentrates, whether they're hashish that are mechanically or chemically extracted, and these are actually extracting the most useful portions of the cannabis plant and leaving behind the cellulose and other things that aren't necessarily medicinally beneficial. And I know there has been a lot of kind of reefer madness scare around these. That, you know, people are calling them the crap of marijuana, which really isn't the case. It's just an extract, and if used properly, then it's very effective medicine. I think that the danger is in the production of some of these. Some of these are produced using butane and other solvents under high pressure in a cylinder. And you know, there have been explosions and fires when people do this improperly in their kitchens and basements and such. And I do agree that that is a huge problem, and I think that's another one of the crystal ball things where we should be looking to the future to regulating the processing of these products, because they really should be done in a lab and production facility and not in the kitchen.
All due respect, I'd like to amend that a little bit. There is this singular distinction between a butane hash oil product or a hash, which is the concentration of trichomes where THC primarily resides. We found that many patients that use great amounts of opiates find this very beneficial. It's extremely strong. The difference between a BHO or a butane hash oil or a hashish product and an RSO is that RSO, or commonly Rick Simpson oil, is a whole plant extract that usually utilizes grain alcohol or food grade product to extract the entire cannabinoid profile from the plant. And while we don't know what CBGs, CBDs, or CB12 does, or what the sequestered terpenes or terpenes and how they affect that, the chandelier effect of it has definitely shown to be beneficial in a number of cases that we've all seen where regular pharmaceuticals haven't met the need. But a Rick Simpson oil, properly done, really is the magic in the medical marijuana movement right now, and it should not be confused with something produced by
If I could just real quick, and I believe Representative Wilson was saying the concern on just public safety wise and that is obviously the different extracts and methods of doing it, but it really gets down to the amount and the concentrations. And I know in other programs, again, not thinking broadly, but a lot of the shops in that were carrying keef and highly concentrated medicines which led to a lot of extra, should I say, danger in the fact for robberies, holdups, because we're dealing in a cash-only business. And I think on law enforcement side and public safety side, when you see 10 regular plants, or the harvest of 10 regular plants compared to 24 ounces of keef or extraction, it's a different volume and a different commodity you're talking about altogether. And I think that's where we were going on that. As a committee, we really need to look, yes, it is cannabis, yes, it is definitely medicine, but there should be something in place to guarantee that as a facility, I'm not sitting on exorbitant amounts of keef or extractions or that outside my patient base, basically. If that makes sense.
Can I, in the interest of the conversation, because I'm hearing a couple of pretty strong views on this, I'm wondering whether it would pay us to go find some experts to come back at the next meeting and walk us through all this. I mean, Rick Simpson oil I've heard about, but I was told that it is has huge chemicals that are in it, and the chemicals may or may not still be in it, and the chemicals may be dangerous. I have no idea whether that's true. It didn't sound like it from what I heard over here. Hashish, I didn't even think about. So I'm just thinking that it may pay us to go bring back some experts on this and help us all understand. And if that's reasonable, we can do that. If we want to continue the conversation, we can, but I'm sensitive to everybody's time.
And I would agree with that, Tom, and I think there's some valid points made, but I think us as a rules-making or advisory body ought to be looking at, for example, and I think the suggestion was made, I think we have to treat these, for example, these two oils differently. So BHO, I think we really need to look at, if we're going to allow these shops to sell BHO, we need to make sure they're made essentially industrially. So we can essentially cut off the garages exploding and catching fire, where that may not be the concern with RSO. So I think we really have to get down to the nuts and bolts of these different products and make sure that we're ensuring public safety and public health for the benefit of the patients and for the benefit of our communities. So, and I don't know Shannon's position on how deep we can go in these rules, but that's another one of the gaps in 3460 that, you know, I see that really needs to be tuned up. Because one thing I would, for example, what I wouldn't want to see is all of a sudden all these shops are selling BHO and they're getting it from these garage guys, and you know, we're having fires and explosions. I mean, we can regulate away from that. We can do this right.
So I want to say one thing, I know we need to move on, but I mean, this conversation I think is, it seems like we have two experts here now who know a lot about all sorts of things, bubble and different oils and different extracts. So I mean, I think my concern is I don't want to regulate how somebody takes their medicine. I'm happy to regulate the production part. I think BHO is on its way out anyway. I don't know if these two people who are much more informed than I am, I think BHO is on its way out. I think you're really talking about other things, other kinds of extracts, bubble hash, shatter, other things that have solvents in them. I just want to be careful not to regulate the way people choose to take their medicine and instead regulate kind of some of the safety issues around the production, which again is really missing from this bill.
Point taken. I like your term. I wrote it down. Don't want to regulate how someone takes medicine, but we do want to regulate the production of that medicine. Did I get that? And I think that.
And I guess I would pipe in and say I'm not sure the extent to which we can.
Right. Okay. Because of the limitations of the bill.
Right.
Got it.
I don't see our rules reaching that far.
I would beg to differ. It seems to me that we have the ability to set up what is going to be the regulatory process of what's coming into these dispensaries. And why wouldn't we be able to hone down as to what is acceptable and what's not acceptable within the rulemaking process?
Well, I mean, we can maybe have some more discussion about this. I mean, the authority has, you know, can adopt rules related to the registration of facilities and sort of certain other aspects of that, but you know, the bill in its face authorizes the transfer of usable marijuana, and that's a defined term, and immature plants. I mean, it just doesn't say anything about the authority's ability to regulate sort of the product itself that's being transferred. But I can take another look.
Yeah, I mean, we could regulate what quality of product a dispensary or facility can bring in and distribute. But if we require that it's produced in a lab and we don't have a mechanism for licensing or authorizing production in a lab, then that's that's problematic. But something for very soon legislative sessions.
All right, should we move on?
Yeah.
Okay. Application process. There's going to be an application. You have to submit all the documents that the authority is going to require that show that you can meet all the requirements in the rules. You have to submit whatever paperwork is going to be necessary for the criminal background check. And the fee, of course. I don't know in what manner the authority is going to accept applications. I think that's still to be determined.
You look at me when you say that, so I'm going to bounce it back to you. Does this committee have the ability to do that, or is that something that is a process that the authority can set up without?
To say whether or not it's going to be submitted electronically or by mail or...
Right.
No, I mean, that's something that affects the public, so it needs to be, I mean, it probably should be
Okay,
described in rules.
I don't feel strong one way or the other. I just want to know who you're looking at when you give the job to. Is it this group or is it us?
I think the difficulty initially, of course, is that since facilities can't be within 1,000 feet of each other, that there's going to be a rush in the beginning for registrations. And it doesn't make a lot of sense to me to have them submitted by mail. I mean, the committee needs to have discussion about what's the fairest way to deal with this. I mean, the way I wrote the rules was first come, first served. Whoever gets in the door first. And so my idea was, you open some sort of on, March 1st at midnight or 8 a.m. or whatever it's going to be. You open a web portal and people can submit things, and sort of whoever pushes buttons fastest gets in the door first. And then as long as your application is complete, then the authority would review that application, and then you might be the first one to get it registered. If you do it by mail and it's postmarked, whoever deals with a piece of mail first, I don't know, that seems less fair. I'm not sure how else it should go.
Well, we'll bring that back. Why don't we take a 10-minute break here? While we're doing that, if the committee wants to think about timing today, we have this room all day. And I'm sensitive to your time and how much time you want to put into this today. So think about that and how you want to wrap this up, if you want to wrap this up before lunch. Otherwise, whatever you have. I have a dead mic down here. Is something wrong with this mic? We're going out. Let's go ahead and get started, please. Can we go ahead and get started? So during the break, I'd asked a question, just before the break, I'd asked a question about how long we wanted to work. The general consensus is we're going to work until noon. In the interest of allowing public comment, we will start that at 11:30. I have, when you all came, you were asked if you were going to want to public comment. This is we will go through as many of these as we can. If you are not signed up on this, the lists are still open, and Teresa will pull those for me at the time. So we're going to do that and take about 30 minutes of public comment starting around 11:30.
I didn't want to talk, I just wanted to change it, so I would like to talk.
Can you fill out the slip outside? Yeah. 'Cause I'm just looking for the yeses down here as I go through. Yeah. So, Shannon, you want to go on? We got as far as the application process, which is unfortunately C, and we have at least to go to X's, so.
Okay.
We have just about 40 minutes to do that,
Okay. So, again, An application will be submitted, we need to figure out how that's gonna happen. It will be reviewed for completeness, so if everything is not there, it's gonna be returned to the applicant as incomplete, and then they're gonna have to resubmit. If it's returned as incomplete, it may be that the authority decides to keep a small fee, just a processing fee, but otherwise.
Just one time. Rep. Buckley, are you still, I just want to make sure that the feed is still working to you.
Yes, it is, thanks.
Okay, thank you.
But then the fee would be, most of the fee would be refunded at that point. And again, it says applications will be reviewed in the order that they're received. I think that's still a policy call that the authority and the advice from the RAC is to make. The fees need to be set. We need to establish under what circumstances a fee might be refundable. For example, that maybe the facility decides that they want to withdraw their application. It's going to depend on at what point the authority is to do their review, whether or not they're going to refund the fee. Any questions about fees? Okay. So once an application is complete, the authority is going to review it to make sure that the facility is in compliance with all the rules. Have to go through the criminal background check process. If there are any other additional questions or documents the authority wants to receive, the authority can ask for that. There's going to have to be some communication between the medical marijuana program and this program to figure out, to ensure that the facility is not located at the same place as a grow site. And again, we have to figure out whether or not the facility is within 1,000 feet of the facility. And you'll see in other parts of the rules, the authority, the way that I've drafted them, really the onus is going to be on the person submitting the application to provide all that documentation that shows that they are in compliance. If the application and everything else complies with the statutes and the rules, and the authority has to grant the application, approve the application, at that point, there will be some sort of document that is issued, again, that needs to be displayed at the facility while the facility is in business. And I assume that that's something that would need to be viewed from the outside. That's maybe a security issue, so maybe there's a little bit more discussion that needs to happen around that. Is it really just something that's displayed inside? Is it something that's going to be seen by the public outside? Some issues that maybe need to be explored. Registration is only going to be valid at the location that is authorized, right? Because campus is within 1,000 feet of all these other places, so you can't, once you're registered at a particular place, you can't take that registration and move someplace else. And again, because of the criminal background check requirement, if there's a new person responsible for a grow site, something needs to be done about that. You can't transfer registration to somebody else without at least that person undergoing a criminal background check. Okay. If the application is denied, the authority has to do that in writing. Tell the applicant the basis upon which the application was denied, and I'm assuming that this would trigger what's called a contested case. So there will be hearing rights, and you have the right to a hearing. The authority ends up issuing a final order after that hearing process, and then that is appealable to the Oregon Court of Appeals, and that's all governed by the Administrative Procedure Act. It's an annual renewal process, so every year there'll need to be renewal. I assume that would be some sort of shortened process. I don't know that the fee will necessarily be lower for renewal than initial application. That'll have to be something that is decided. Notification of changes. The person responsible for a facility is going to have to notify the authority within a certain number of days whether or not they've been convicted of one of the crimes that would make them ineligible to be a person responsible for a grow site. There's a court order that says that the person responsible for a grow site can participate in the medical marijuana program, change in ownership, a decision to close the facility, and intend to move to a new location. And these were the things that came to my mind. I left blanks here so that if there's any other things that you think a person responsible for a facility should notify the authority of because it's some sort of change in circumstances, then you can fill that out. And then failure to notify the authority of any of those things could result in revocation of the registration. Business qualifications, as I said, the statute requires that you be registered with the Secretary of State. It may be for some reason that at the point you apply, you don't have registration yet, so you could show proof that you have applied. But I think prior to OHA actually registering the facility, you have to have registration with the Secretary of State. That's sort of how I am suggesting that it go. So KKK, section KKK. Is about locations. This is, again, mostly the stuff that's just what the bill says about where a facility can be. The documentation that's going to be required to show the authority is something that shows the zoning for the location of the facility. Maps, again, that show the location of the facility in relation to the schools around it. The facilities are not going to know, I'm assuming that the authority is the one that's going to figure out whether or not this location is in 1,000 feet of another location, because applicants are not necessarily going to know that. I mean, they may know, at least initially for sure, because there aren't going to be other registered facilities. That's not going to be a public list. That's not information that's going to be publicly available. They may know because they know the neighborhood and they know other business owners and they know what's going on. So the authority will figure that out. I tried to put in, again, putting the onus on the applicant to provide the authority with as much information as possible so that we can figure out whether or not a facility is in compliance.
Shannon, can I back up 1 minute? You said that the list of registered facilities is not a public list? Okay, having gone through this with the program that we thought we specifically exempted from freedom of information, is this written tight enough to exempt us from freedom of information?
Yeah, the change is to 475-331, which is the current statute that governs your cardholder and growth site status under the Medical Marijuana Act, and so facility locations were added to that list as being confidential, and so what the position of the medical marijuana program is that because that information is confidential under state law, right? There's an exception under the Public Records Act that says if state law makes something confidential, then you don't have to disclose it. If we revoke registration, then that is public.
I remember the discussion you and I had on the prescriptive monitoring program, where we thought it was exempt and turned out not to be.
Yeah.
Not to go backwards, I was just going to ask you on that, since the records are not public, when I apply, if I'm a center or a facility and I apply now, you're saying I won't know if there's any other centers within 1,000 feet of where I'm at, so that responsibility is going to fall upon the authority?
Because we'll know where the registered facilities are. This is, we had discussions about this. This is not my favorite part of the bill to make this information confidential. It sort of doesn't make sense to me. This is a business registration process.
And the only point I bring up for you and Rob, actually on the legal aspects, is from federal case law, and I know this has nothing to do with federal, but a lot of the U.S. attorneys definitely go after centers that are within 1,000 feet of schools. And the definition in the different districts are, as the crow flies for the 1,000 feet, is it actually physical distance from front door to front door, and so forth. And for us to put ourselves in a position where we're granting a license saying, giving them that they're not within 1,000 feet even of another center or the medical marijuana program, puts us then in a position of saying, are they within 1,000 feet of a school? Where do we draw that line of what we're approving and not approving?
Well, yeah, I tried. based on some other state law in sub 4 here on the top of page 5, it talks about how the measurement is happening. And I think it remains, you're right, how the authority is going to figure out the distances between facilities. I don't know, Google Maps.
They use the 1,000-foot long tape measure.
Yeah, right along.
But I would say, just as a committee for ourselves, not always saying that the big ugly federal government is sitting right above us, but I have seen in other states where prosecution, and I won't say selective, but prosecutions have come out with that 1,000 foot. And when our definition of schools in public schools, I know that U.S. Attorney's Office a lot look at if the school is public or getting funding from the government, that opens them up. So I'd be very careful if we're going to make a distinction between senior high and vocational or college or graduate studies, in the fact that if that institution is receiving federal subsidies or federal money, again, in the safety and caution of the store, the shop, the facility, I would be very hesitant to say, oh, don't worry about that. Because that still is one of the things, that 1,000-foot marker, for whatever reason, and whoever picked that, for safety and abundance of caution, I would definitely say, as rule committee, maybe we look at always saying 1,000 feet from things.
Well, again, there's nothing in this registration process that's going to keep someone exempt from any federal
Right.
prosecution. Okay. Should we move on?
Oh, sure. Sure. I was just, as the conversation was going on, all the GIS mapping is what gets used today. It's all very definitive, all of the planning departments use it, and they have all the tools necessary there to make sure that it is within or not 1,000 feet of that particular location. So that's all I was going to say.
I sort of assume that these businesses are going to make themselves known. Maybe I'm wrong about that, but I mean, it's sort of strange that as a program, we've got to keep that information confidential, which, you know, whereas they may have their presence on the web or in the yellow pages, you know, I don't know.
I'd like to address that a little bit. The intent of adding the facilities to the list of patients and registered grow sites was so that law enforcement would be able to access those locations, not necessarily to keep them private. The fact that they are businesses and they're registered with the state and they're in storefront locations, you know, it's clear that they're public entity, or they're at least in the public view. And so the idea was not, again, to keep the locations or the names private, but to make sure that that was part of the list that law enforcement could access to make sure that facility was licensed.
And they're going to be registered with the Secretary of State, so I don't know if there's a way to search Secretary of State's website for, you know, sort of this particular business type.
But again, it got, the bill added it to 475-331 sub 1. I mean, I understand why Jeff, you wanted to cover it under 2 and 3 so law enforcement could access, hey, is this a real registered place? I get that, but you also added it to sub 1, which meant that the authority can't tell anybody. So, and that struck me as really odd. I think we ought to fix that too.
It makes, I mean, I'm sitting here thinking as the agency that has to administer this, I don't know that it's a burden on us, but if Jeff has a facility open, does Todd want to go to the effort to open the facility if he has no idea where Jeff's facility is and whether it's within 1,000 feet of each other? And if I can't tell Todd, he may go through a lot of work before I get in and say, oh, Kickle, guess what? I knew that, but I couldn't tell you. So it is something that's on my list.
Yeah, I mean, this is big. I mean, I think this is an issue that we should seriously think about.
But,
because how do you decide, you know, where you're going to apply or where you're going to put your business if you're not certain where other facilities are located?
Yeah, so it seems to me keeping personal information private is one thing, but the program could still let a prospective owner know if this address is within 1,000 feet of a place that's already registered?
Before they go to the.
Before they go through the effort of paying the fee and going through, loss of the, like, non-refundable
saying
license
where.
fee. Without saying
That's
where,
interesting.
without saying exactly who owns it, just that there is one within 1,000 feet of where you're inquiring about.
We'll have to work on this.
Yeah.
Again, I don't know why a list of places that operate these facilities shouldn't be public. I mean, why shouldn't patients know where the medical marijuana pharmacies are? I mean, that doesn't make, I don't understand why we would want to keep it secret where these facilities are. Am I missing something?
Oh, yeah, I don't think there's a great intentionality behind keeping it confidential. It's just how it turned out. But yeah, let's put that on the list of crystal ball legislative fixes. In the meantime, if the program that administers this has the ability to easily find out if an address is within 1,000 feet from a school or another facility, that perhaps there may be a mechanism for people to pre-apply or just do a query to the program of an address. And I think Anthony was going there too, that they bounce back and say, yes, that's not within 1,000 feet, or it is.
The other interesting thing, of course, will be since facilities can't be in the same location as a grow site. How you deal with that, and again, once a facility is registered, then it also means that patients that are applying, that want to list a particular, that might want to list a dispensary as their grow site are not going to be able to do that. So, okay, well, let's keep moving along because we don't have much time. Person responsible for the medical marijuana facility, again, has to provide proof that they're a resident of Oregon. I set out some things that I thought would establish that proof. We still need to figure out what it's going to mean to be a resident. You have to live here for a certain period of time. I mean, this is where I sort of put in that a person responsible for a facility has to have legal authority to act on the facility's behalf, is responsible for ensuring that all the laws are complied with, sort of things like that.
Just curious, sub D there, location and resources to open business. What were you getting at there?
Those aren't my words.
That was mine, and I just, this went back to the conversation we had earlier about a dummy face. And again, that was just sort of a placeholder in my mind of saying, we have this clean person who puts the face forward, funded by, supported by organized people who are not.
Okay, criminal background check process. We're allowed to do a criminal background check in accordance with, I think, 181, 534, I think. So anyway, the Oregon State Police rules about how you do criminal background checks. Again, I'm assuming that this is going to be a nationwide criminal background check, which is going to require fingerprints. So the person responsible for the grow site is going to have to submit fingerprints, and then it's an FBI check. We have to have, the authority is required to have certain rules in place if it's going to do criminal background checks like this. I don't know what the fees are. I want to say they're like around $85 or something like that. Yeah, I mean, all this stuff is just sort of to comply with the statutes and rules around agencies doing criminal background checks. I don't think there's any surprise. This criminal background check information is information that the authority will be required to keep confidential. It's only going to be used for purposes of determining whether or not they have these particular convictions. So, the security and testing are just placeholders. Record keeping. There are some things that the statute requires a facility to keep track of, the authorization forms that a patient is going to fill out. Facilities are supposed to keep track of transfers of marijuana. I tried to include other things that I thought were pertinent, things that would allow the authority, in going in and doing inspections or asking for records would enable the authority to ensure that the facility was complying with the statutes and rules. And I also added some provisions about, excuse me, requiring some record keeping that shows how they're coming up with sort of these reimbursement costs. And that was mostly to protect patients, I think, that are going in and getting usable marijuana
That's
or
an
plants.
H.
That there needs to be a relationship between the reimbursement costs and, what that's being based on. That it's, that it's somehow real and not just the market rate that's garnering profit.
What other businesses are asked these questions? How do you define? I don't mean to be adversarial in any way, but would not regular market forces make the greedy people less attractive to the consumers who are choosing where to spend their healthcare dollars?
Well, so for example, state agencies often can establish fees for things that are supposed to be representative of the costs that they're incurring for that. And so it seemed to me to be sort of the same sort of standard. Again, this is sort of, my idea of how this might work. Part of the bill talks about reimbursement of costs. If we want to be able to look at that, then, we need to know what numbers the facilities are using and on what basis they're establishing their dollar amounts. If the committee, thinks that's a bad idea, then the authority can take that into consideration. But I thought it was worth discussion.
No, very good discussion, but with no, a facility is going to be a regular business, so just following regular business standards from other models. The cultivator, the gardener is going to know exactly how much product he's getting per light, what the light expense is, this and that. It's nothing more than a regular business. When you sit down at the end of the month and you write out your bills and you see it's cost me $6,000 this month to stay in business, add in your employee fees, divide that out. It's not asking any additional bookkeeping per se, but it really was just a regular business accounting of expenses in, or I should say expenses out, and inventory coming in.
And I think the difference is that regular businesses don't have statutes that say that, you can get reimbursed for your costs. It doesn't say, it speaks to sort of how you're supposed to be, the manner in which you can get money for transfers of usable marijuana in plants. Okay. The next section deals with transfers. Again, a patient will have to authorize the transfer. I think the authority will prescribe a form. The form's going to have certain information on it. The things listed here, again, were just my ideas of what would be on that form. Open to discussion, of course.
Can I say something? I find this to be the most confusing section of the bill. And I've read this now a number of times, not what you suggested, but, and I still am unclear, and maybe it's because I just cannot seem to read this right. So if I'm authorizing my grower to provide my medicine to that dispensary, does that regulate that grower? Does that require that grower to then deliver that medicine to that dispensary? I don't know if I'm reading this wrong, but I think the way it's drafted is a little bit confusing for me. So what if I'm a grower and I want to take my medicine to a dispensary closer to my home? Does my patient need to authorize that grower to that particular dispensary? So I find it to be confusing in terms of the transfer. I'm glad you're nodding because I felt like maybe I just misunderstood this, but I do find it to be, if I'm a grower, can I only distribute to a dispensary where one of my patients has authorized me to do so?
That's the way that I read the bill, and I think the reason it's set up that way is because the law says that medicine, right, is the property of the patient. So, but you're right, I mean, what if the grower doesn't want it?
I mean, that's a real problem, right, with this bill. So I can, if I'm a grower, go to whatever dispensary I want and supply them with medicine, at least how I read it, and I think how you read it too. So I don't know if we can, if the way it's drafted is loose enough to make some changes within that, or if it's simply about changing the ownership rights. But then if you change the ownership right, it defeats the purpose of having a patient assign an authorization form for a grower for that dispensary. I just think it's insanely confusing.
I mean, you could, I guess, have the form, I mean, if the patient's not serving as their own grower, and they have a third-party grower, you could require the form, if the grower is authorized to transfer, then the grower would be a sort of a signatory, would have to sort of sign on to the agreement. Because I don't think the patient can't force the grower to, you know, make trips to the facility and transfer marijuana. I mean, they can authorize it, but I don't.
And I think I'm less concerned about that. I'm more concerned about the grower being able to take their medicine to whatever dispensary they think is an appropriate middle person for that process. Because I don't think that that's addressed in here. And I do think, you know, then you really are, if the patient is the owner, then you really are limiting the grower significantly. So I think it's not so much about that, it's more about limiting what the grower can do with their meds.
So it seemed to me what maybe Amy's getting at is that, is there a way we could do like a blanket authorization, so the patient allows the grower to get reimbursed from any facility, not just one in the neighborhood or one, wherever. That way it provides flexibility that works best for the grower as well.
And not to be my own devil's advocate, but then you run into the problem of what's the purpose of the patient? So if the patient is just somebody allowing their grower to deliver marijuana wherever they want, then it's really, then I think maybe how you make that even more clear is you say, after I've received my med, after I've received the appropriate amount of medicine, then you open up another whole huge problem with language like that, I think. So maybe that's the only solution, but I think then you just have a patient who's facilitating the, you know, I do things from the worst case scenario prosecution, and I mean, then you just have a patient who's aiding and abetting the commission of a crime. That's how I think federal law enforcement and some counties in this state will view it, where at least I've worked, is that the patient serves no real purpose other than to aid and abet that delivery. So that concerns me.
I agree with Amy. I found this the most confusing, and I think it gets back to what you mentioned before, which is this whole artifice that we've created. Because, I mean, to put it in pharmacy terms, it's almost like pain patients own the OxyContin in the Purdue factory before it's even sent to Gary's shop to give to me. And now we're creating a whole new system that has to somehow acknowledge that. I mean, we're twisting ourselves around, and I see all the problems that you point out, and I agree with. I don't know how to fix it other than legislatively. I don't, and Shannon might disagree. I don't know that we can fix that through the rules. It's another one of my punch list items. Sorry, Tom. That's.
I think the bill, go ahead, Jerry.
Maybe that's fixable, I don't know, but maybe I need to be educated, because I'm missing something really basic. If I'm growing marijuana for Rob, which I'm not.
Okay, well then what did you do with it?
So I took it to a dispensary. If I'm growing for a patient, why am I then taking that to a third party? I guess that's what I'm missing.
Basically, under this law, I think the concept is that the grower provides for the patient's needs. The medicine belongs to the patient. The patient gets 2 ounces, 4 ounces, whatever works, whatever they need. Their needs are met, and then they are allowing the grower to get reimbursed for their supplies and utilities and cost of doing business, so the grower can then recoup the expenses they put out on lights, nutrients, water, soil, things like that.
Not every What's the purpose of the dispensary?
The dispensary is needed to provide safe access points for patients and provide the mechanism for growers to be reimbursed for the normal cost of doing business, because under the original Medical Marijuana Act, growers can only be reimbursed for supplies and utilities, not for the customary cost of doing business.
The reason for the dispensaries is that many patients can't or won't grow for themselves and don't have a grower and don't have access to a grower. And that's what's led to the creation of all these dispensaries, because patients are looking for a safe access points to get their medicine. And so that's the rationale.
So the patient that doesn't have a grower would access that.
That's right.
That's still missing. The patient that doesn't have a grower would use the dispensary. But if I do have a grower, why don't I have that grower send it to the dispensary? That's
There are a lot of reasons for that. Yeah, so dispensaries are for patients who don't have a grower. That's clear. Patients who do have a grower, growers sometimes succeed and sometimes fail. So a dispensary would be very valuable in the event of a crop failure. Also, the patient who gets diagnosed with cancer today, gets their authorization today, signs up a grower, but that grower can't provide medicine for another 3 or 4 months until their crop comes in. That patient needs a dispensary. A patient who has a grower who's reliable at growing strain A and strain B, which is good for their appetite and nausea, but isn't able to produce enough medicine to help with their pain, needs a dispensary. So they're a great deal. And also I think one thing that we could add to this patient authorization, you mentioned the patient indicates the maximum amount that a grower can provide for reimbursement. Also, perhaps a section that says after a minimum amount has been provided to the patient, then the excess can be transferred to a dispensary. I think that's an important part as well. But also, one thing I just need to point out is, you know, I don't know anybody's medical history on this committee, and you don't need to disclose it for privacy and everything, but my sense is this committee lacks the representation of patients who do need dispensaries and who will be relying upon them. We want to also bring in other experts such as lab technicians and such like that. We should also probably bring in some patients who are in that position as well.
I don't disagree with anything Todd said, and I actually agree with everything Rob said, so I can't wait to come to your county and defend one of these cases, but I think that it doesn't...
You won't have to. You'd be defending Gary, actually. He's admitted here in open public session stealing all my...
So, I mean, and I come from a different perspective, patient or not, but I think that the real issue is when I look at these and I look at the statutory language by which people who are enforcing this work, that I think there are some legitimate concerns about the ownership. I think there's legitimate concerns about what rights patients have over the entire crop of medicine. I think that there's a true concern for me about, you know, somebody, if we're worried about somebody being a front for a dispensary, I think the federal government has made it extremely clear they are worried about patients being fronts for organized crime. And so we want to make sure when we rule make this, that we're providing protection to patients, growers, and dispensaries in a way that, you know, I know that's not the job to provide protection, but I think just like the within 1,000 feet of the school, I think Mr. Schmidt had a great point, which is other than businesses should all be doing their due diligence in terms of being within 1,000 feet of a school, we should not be setting these people up for prosecution with the language within the rulemaking. So that's my concern.
Okay, we've got about 7 minutes. So let's move on. I mean, there's lots of stuff to discuss and transfer. I think we're going to have to review, and maybe Tom's going to tell people whether or not they want committee members to get language or anything. So inspections, the authority has the right to do an inspection. Again, I mean, this is just stuff off the top of my head, whether or not you would do an initial inspection for every registration and then one every so often. You need to, you know, facility needs to cooperate with the inspection. And again, the inspection would entail trying to figure out if the facility was complying with the rules. Violations, just trying to make clear what's a violation, what would be considered a violation for purposes of enforcement. Sort of informal enforcement and formal enforcement that I put in, and this is again sort of similar to other ways that the Oregon Health Authority licenses facilities. You try to do things the easy way before you go the hard way. So when you go do an inspection, you find some violations, some non-compliance, the facility would be given a certain amount of time to come into compliance, and then everything would be forgiven. If those things aren't corrected, or if it's something that's super egregious, then you move to formal enforcement, which would mean like the revocation of the license again, which you would get appeal rights from that. Section on confidentiality is trying again to make clear what information is confidential. And then I stuck this change of location thing in at the end to make it clear that if you were changing your location, you would actually have to reapply for the new.
If the changing location and reapplying, is that directed from the statute, or is that just the proposed?
That's just proposed. But again, since location is important in relation to other things, and I'm not sure, it's going to require, a lot of work on the authority's behalf if you're moving to a new location, I believe. So I'm assuming you want a new application with a new date.
In furtherance of that, I definitely say one of the greatest expenses, again, back to the funding, is when the initial applications come back in, as you were saying, will there be a physical check at the facility? And yes, there would be a physical check to verify the address is correct, it does exist, the doors are open, it meets the standards that have been established by the rules committee and so forth. To change that location, you go through the same process again. And each time you say that, it sounds simple, like it'd be one location, but what we haven't even kind of gone into, which we'll see as this evolves, is more than one facility belonging to the same person or the same group or the same organization, and all at once they have 7 throughout the city or up and down I-5 and so forth, with rows scattered in the various counties and stuff. And these are all things that, as compliance, going out to verify this is incredible resources and hours of time is spent on that. And again, it goes back to the funding. If you don't have the people to do it, how do you make it accountable, safe for the patient and for public safety?
Okay, Shannon, go ahead.
Just follow up on that. I mean, I understand the need for the funding, the fees to make this happen. I don't know if we have to require someone to go completely through a complete new application as much as having a modification that still has a fee to it. That says we're wanting to move from point A to point B. It seems like if nothing else is changing except the physical location, we should be able to build in a process that will allow that to occur without going through this whole process. Because if you're, I don't know if you need to rerun all those background checks again, that type of stuff. So I think there's ways that we can ensure the viability without necessarily going through the complete process.
Yeah, just to follow up on Senator Brzezinski, it seems to me if you're looking into the future, if there is the funding, we have a medical marijuana facility that's operated for 5-10 years, they've been following all the rules and regulations, they find a location that works better for them. If the authority knows that the new location is not within 1,000 feet of a school, not within 1,000 feet of another location, that there could be a process set up that will allow businesses the flexibility to move to better locations.
Okay, well, thank you, Shannon. Thank you, everybody. So, committee members. Yeah.
Can I say something just quickly? I have a disclaimer. The questions I had a minute ago about the dispensary and the patient and the freeway, I didn't want to imply in any way that the Board of Pharmacy has a position on what the value of the dispensary or the need of a patient to get marijuana. I was just trying to understand that freeway.
I understand. I think Rob may have you on something. Okay, so in the interest of time, which is right at 11:30, I was going to do a couple things. First of all, next meeting. This room provides a lot of luxuries. One is sort of halfway between Portland and Eugene, and that sort of seems to be where the committee members reside, and so if we go from one end to the other end, people are going to have to travel further. Secondly, it allows us to stream live, which means that people who can attend can actually see what's going on as opposed to just hear. Third is it's a big room, and it's in a public space as opposed to some of the rooms in the HSB, which are behind security. I mean, you have to sign in and show ID to get in, and I'm sensitive to that may be an issue. Unfortunately, if we want this room, it's very difficult to get this room. And so in the interest of time, I'm going to propose 2 dates. One is Friday, October the 18th, and Tuesday, November 12th. We have this room reserved. If those dates are a real serious problem, we need to know it now, and we'll start looking for other rooms. I will alert you that finding rooms to handle this size crowd and these facilities, and I'm also sensitive to your schedule too, which is, you've got some, yeah.
I personally do have an issue with the 18th with voter obligation. I know we're looking at that week. We could clearly find, I think, a room very similar to this at the Capitol. And we, again, would need to be able to have the opportunity to get it scheduled. At this point in time, the legislature is now meeting on what we call legislative days. And so there's 6 hearing rooms on the main floor and many others that we should be able to tap into without much problem. And so when I saw the memo, Thomas, you sent out, you're looking for a date that week. And so I'm hoping that maybe we can have a little bit more flexibility.
I'm open to anything. I consciously didn't pick the Capitol because it creates a rostrum, and that was just, I just wanted sort of a more informal conversation, but I'm perfectly willing to go to the Capitol because you're right, they have great rooms, they already have the facilities in, and every one of us has a mic and supposed to have mics around, so that would be, yeah. So if the 18th absolutely doesn't work, we'll go look at the Capitol. Anybody else want to weigh in on the week? And again, my goal for picking these weeks is, that's about 4 weeks from now. That gives us time to digest all your comments here and start narrowing the conversation points. It gives time for the subcommittees to go off and do the work and come back at that meeting. And again, remember, December 1st is sort of our drop-dead timeline for this. In order to meet the needs to have this rules in place February 1st, so that people who want to apply can apply on March 1st. So the 18th is off, is what you're saying. It is, okay. Does anybody else want to take another date off that week, Rob?
I would just take, I think I can speak for Amy too, take all Mondays off. Mondays are just bad for trial lawyers. But I'll make it work if you have to.
I'll take that, and I'm okay. I guess weekends, all right.
Well, you know, Wednesday the 16th or Thursday the 17th, if that would work for an individual.
I'm at a national conference, criminal defense lawyers conference that whole week, and then I'm trying to get someone in your office the 22nd, 23rd, and 24th in Wasco County. So those are my only real bad days, the 23rd, 24th, 22nd, 23rd, and 24th, and the entire week of the 14th on in Savannah.
Of October.
Of October.
Okay. So we're now starting down to find that my brilliant idea of doing this isn't going to work, but I will. Okay, anybody else have problems with sometime that week in October? Again, I'm looking for the 14th. You can't, Amy, I hear you. I got it.
Yep.
have board meeting for 15, 16, 17.
Okay. Okay, this is not going to work. Amy, you're back on the 23rd or 24th of October?
I will, but I'm in a trial in Wasco County.
The week before.
We can go the week. All right. I'm going to tell you a secret. It doesn't for me. We can do it. I get back from vacation on the 14th, which is what I take on the 14th. So unfortunately, I get to veto those. Let me do a quick survey, email survey by everybody instead of taking this time. Also, look at the week, look into November with the same question. Again, this room, although I appreciate November 12th, which is the day, which is another Monday. It's technically a Tuesday, but it's the Monday after a 3-day weekend. And I'm sensitive to the legislature being in session
Yeah, we're not in session until the 20th.
Until the 20th, okay.
21st and 22nd.
Okay.
I can also send out a poll.
Yeah, we'll get a poll out. If you could try and respond by late Monday, sort of what works, what doesn't work, and what we unfortunately have to take the majority. I mean, I will do everything I can, but otherwise. A couple other things. We've got a testing subcommittee working. We've got a security subcommittee working. We've got a local government subcommittee working. I didn't know, did we come to some consensus that we needed to get a group of specialists together on the transfer issue, or do we want to hold that here to talk about that? I didn't quite understand whether that's something we want to do, or we want to go off and find grower experts and people to talk about that. I'm looking at you, Amy, because you seem to have the most concern. Do you?
I'm interested in being involved in the transfer part of this, so I'm happy to, I'm happy to pull growers in. I'm interested in having a significant grower involved. I am also interested in having law enforcement, I think, from a protection perspective. So I'm happy to be involved and head up that committee.
Okay. Then why don't we do that? And again, when I say subcommittees, this is just really means to bring back experts, so that you're also going to bring back a video on the whole grow thing. So we understand how to grow pot. Okay, with that in mind, we're going to open it up to the public. I'm going to ask the public to follow the same rules I asked the committee members. What we need from you right now is what is not in these rules. I understand there are things that you may not like in the rules. I understand things you may want changed in the rules. But right now, what we need to know is what have we missed that needs to be addressed in order for you to actually run one of these facilities. And it's going to be random. I have sign-up sheets. I don't know the order of the sign-up sheets. And I'm going to try and limit people to about 90 seconds. So Chris Schatz, followed by David Morse. If you guys want to come up to the podium here. David, if you want to come up right behind Chris. And then I'm going to go to Steve Gibson. So if you guys can start lining up over here, it will make this facility a lot easier. And I am going to have to, ask you to be very, very quick.
Absolutely, no problem. First of all, just let me thank you all for this innovative and fantastic work you're doing. The thing that I would like to be, my concern is with respect to funding. I know it's important, but I would also urge you to consider in setting fees that it's important that both we have different communities in this state that have different levels of need, and we have a tradition of supporting smaller businesses that are innovative and quality directed. So when you set these fees, I'd like to think about possibly thinking about a graduated scale that deals with the fee setting, whether it's annual, initial application, or whatever, based somewhat on the scale of the size of the facility that's contemplated by the
Was that Donald Morris or David?
Donald Morris.
Okay, I'm going to take this later.
Okay, all right, that's okay.
Thank you guys for being
Steve
here.
Gibson, you're up on deck.
I just wanted to talk to you guys a little bit about the reality of the two systems that currently exist, consignment versus prepaid medicine and the ownership rights to the medicine for the patients. If a patient, let's say that Jeff is a patient and Todd, you're the grower. Jeff is a member at any facility and he authorizes Todd to bring in that medicine. What happens is, let's say you produce 3 pounds, okay? You give 24 ounces to your patient and you bring that excess medicine to the facility. If it's on consignment, then if at any time Jeff wants medicine back because he uses that 24 ounces, the facility can return that to you or to the patient. If it's prepaid by the facility to the grower, then that patient can no longer have access to that medicine. So that's kind of the way that it works right now in the existing facilities, okay? I just wanted to bring that up. In regards to the testing, the medicine should go to the facility so that it's in a neutral place. The facility takes out the sample, let's say 2 grams, and that goes to the lab. The test results go back to the facility, and that way the grower, it's not transferred all over the place. It's in a bulk package in a secure facility at the MMF, and it's not molested or tainted or switched or anything like that. And then the facility can ensure to the consumer that it was not mishandled, and here are the test results to prove that it was, passed the results. as well as the fact that the facility can return any tainted or negative, test result product back to that grower and record that. I had a question for you, John, in regards to the GIS maps. Does that GIS offer boundary to property boundary as the crow flies, or does it only show a driving distance, or does it do both?
Just both.
Great. One thing about the growers that's been kind of brought up, I think a little bit from you, Paul, is in regards to growers and in regards to the fact that growers are not a business, okay? They're still kind of working for that patient, and that's really where it lies. And the growers don't grow for a specific medical marijuana facility, whereas in Colorado they do. So there's where some challenges lie in how to determine, the ownership and the transferring of medicine. So just want to keep that in mind. And I think that's all I have to say. So thank you.
Thanks, Sarah. Steve, and then R. Atkin. You're up next.
One of the things that I was concerned about that wasn't addressed was the delivery to a patient within 1,000 feet of a school. Not only just the patient themselves, but what about the disabled and elderly that might be in healthcare facilities? I've known in the past that you could be charged with a charge for delivering that product within 1,000 feet of a school. So, and that's something that's not addressed. And I think we need some clarification on that, because these people that are in these facilities obviously are not able to go out and make their way physically to a dispensary or facility, or whatever you want to call it, a clinic. So I think that's something that needs to be addressed, and it needs to, we need to have black and white on that.
Great, thanks. Anthony Taylor?
Just like that.
Okay. Brandon Johnson? Okay, go ahead. I'll turn the page.
I'm curious about the separation between growing and retail. I haven't heard any justification for that, but it seems to me if you prevent a farmer from bringing his crop directly to market, you cut off potential profits of the grower, his financial, financial ability to run his business. And it sets up a conflict of interest, because retailers are a totally different business from growing. They have their own self-interest, and they would, in my opinion, retail is subject to consolidation, and if that occurs, then you'll have a situation where retailers have pricing power over the growers that may be an undue influence. This is a problem I see in Washington's legalization, the cutting off of growers from bringing products directly to market. Now there are examples in Oregon law, for example, with craft distillers, where they have multiple routes to bring their product directly to market. I'd like to see this considered a little bit more from you guys. Another thing I wonder about is, in the law as it was passed, it says all normal costs of doing business are allowed. So why would growers have to provide justification for reimbursement? And it sounds essentially like they would have to provide an income statement. When I don't know of any other businesses that are required to do this. Tell me for that. That's it.
All right, thanks. Let's see, Brandon? Brandon Pines?
Going down.
Okay. And after Brandon is Lindsay Jacobson?
I have questions and comments regarding so can we not have a specific grower for a dispensary? You can't have somebody that is maybe certified through OHA or the state or whatever that can abide by, I heard something from an organic earlier or whatever. Will dispensaries be allowed to have their own grower that the dispensary itself knows, I know that my grower is using all organic, I know my grower is doing this and that. Is that something that we're going to address, or is it essentially just going to be patients and growers for themselves bringing it to those dispensaries?
I have no idea, but we'll certainly try and find an answer for you. Yeah. And what's the process to see if we don't address that?
Okay. And another thing I was thinking about is as far as I know that a patient on hand should only have, 24 ounces. And so I'm wondering, as far as a dispensary, how are we going to regulate that? And then earlier we brought up the fact of concentrates. Concentrates are on a completely different scale, so how are we going to say how much of a concentrate weight can be in this location? Those are things that I'm kind of curious about, that I think essentially not to be prosecuted or get in trouble, that each shop needs to know exactly what they can have as far as each product, because essentially they are all usable marijuana, but it is different products in themselves that do different things. So I think that maybe regulations as far as that would be a really good thing to go over.
Okay, great, thanks.
Thank you.
Okay, Lindsay, oh, that's you. Did I ask Kurt Jones? Kurt Jones, okay, Mel Barniscus. And then Jason Ramsey.
I just want to first extend my thanks to everybody for being here and dealing with this, because it's vital to quite a few people in this state. Your time is appreciated by patients like me. The reason that I'm here is to kind of maybe confuse or hopefully unconfuse, at least as far as I see the issue of the transfer. Right now, growers grow for patient under the authority of the Oregon Medical Marijuana Act. What I think we're not really narrowing down is the fact that we're talking about a transfer of excess medicine. This is where those of us from Southern Oregon may have a slight advantage over those from Northern Oregon. We know what excess looks like. And what we're talking about is the fact that up until now, our option has been to destroy that. And destroy that medicine and keep it out of other patients' hands unless we can find somebody to give it to. That's where these dispensaries are going to be valuable. They're going to take not patient's medicine, but medicine that patient by law is not allowed to have at any one time because it's too much. Put it in the hands of the dispensary and get it out to all those other patients who don't have a grower yet, whose crops have failed, who got federal terrorism intervention on their medicine. We need the medicine available for them. We grow more medicine than our patient is allowed to possess. Let us put the excess in the hands of other patients so everybody has the medicine they need when they need it.
Jason Ramsey.
You've already addressed my concerns.
Okay, Carl Christopher.
I'm going to transfer my questions over to Andrea.
Okay. And while she's coming down, Andrea, followed by Jake. Don't have last names on those two.
I too want to thank everyone, but I see that we have an issue that nobody has talked about yet, and that is there is a real problem with the medical doctors are now being threatened. Many of the patients use more than just medical marijuana for treatment of illness, and they are being threatened. They have to choose one medication or another. Doctors that have been signing for the use of these medicines are now withholding medications from literally dying patients. And so we need to also protect their rights to use this medicine and not be threatened by the medical community. So that's something else that I hope everybody remembers, that we cannot threaten people that are already sick and withhold medications because they may need more than just one treatment or another, or have to choose which treatment they'll use.
So maybe I'm naive. Who's threatening them?
The doctors. The doctors are being threatened.
But not who are the,
It works like this, Rob. The doctors have a DEA license.
Right.
And the doctor's concern is that if they prescribe medical, if they prescribe...
recommend medical marijuana.
No, recommending medical marijuana is not the issue. They have a patient in front of them who they know has a medical marijuana card, and they prescribe an opioid or some other controlled substance. They fear their license may be at risk.
Okay, so that's a licensure issue.
That's a licensure issue,
Yes.
which unfortunately is not in front of us.
No, but I'm just saying, I hope we remember this, because I know doctors that actually have been signing these cards for quite a while, and now are coming to their patients and saying, you have to choose one or another, and not even giving them a chance to come off of those medications, saying, it happens and it happens now, and they'll withhold medication from a dying patient. So that's a real issue for patients.
I will tell you, as the health authority who runs the Medicaid program, we are absolutely aware of this problem, and it is a huge problem, and we know about it. It unfortunately is not in front of us today.
Right.
But
I just want to bring that up.
I got it. Andrea?
Thank you.
Hi, my name is Andrea Adams, and I am a patient, a citizen of Oregon, and I have been operating a safe access point in Southern Oregon. And I again want to say thank you for being here and let each and every one of you know that as you're slogging through rules and regulations and law and points, that the work that you're doing here is going to mean immediate, significant, and regular relief in the daily life of thousands of people that need that. So thank you for doing this work. A couple of things that came up for me were, I know the usable marijuana definition came up. I know we're talking about edibles, there's also topicals and the concentrates and a lot of these issues, and just a suggestion that maybe a usable marijuana for facilities definition could be brought up, or something that says, you know, until such time as all of these processes and standards are met and the testing's been done for all of these things, that it's not usable for a facility to transfer or something to that effect. I also, although you guys brought it up, it's not in the law, the testing, labeling, or the labeling and packaging requirements I think are going to be vital and really important, not only that they work for the patients, but that they are manageable for the facilities. And so I think that that's going to be really important. And I would really encourage people that are working on the labeling piece to make sure that the information that the patient is going to actually receive in the end is going to be valuable information for them controlling or mitigating their actual health needs, rather than code or whatever that looks like. So real information about what's in the product and how that can help. And then again, coming from Southern Oregon, and the issue of excess comes up in a large way, especially at this time of year for us down there. Most people down there grow crop all season long. They harvest one time of year, and then they're relying on that for the rest of the year, which means that at certain points of the year, people are way over excess. And it's a really scary situation for a lot of the growers that are providing this needed medicine. And so I wanted to kind of follow up what Amy had said, that the growers really need protection here. One way or another, it needs to be written in, or facilities are going to have no medicine to give the patients, because growers are not going to come out, write down on paper that they are breaking the law, that they are over the excess for no additional protections. And I think that maybe through the dispensaries or the transfer agreements, they could be protected under the facilities potentially, or something like that. But I know I'm representing, and I've had a couple of groups before this meeting of our producers down there, and it is a huge, huge issue. And so, you know, Amy was the only one necessarily bringing it up, but she's speaking for a large group of people.
Great, thank you. Jake, and then after Jake, we're going to go to, too many pages here, Jerry Norton and John Sayo.
Hi guys, thanks for having me. I'm Jake Lewis, business partner management with THG Enterprises out of Corvallis. One thing I'd like to bring up to mind is that not every dispensary is going to be in a major city where there's tons of land to go around. As you know, Corvallis is pretty small, meaning you put somewhere downtown, 1,000 feet, that takes up quite a bit of area. A dispensary is not something you can plan overnight. This requires months and months of game planning, lots of logistics, figuring out where your stuff is going to come from. Ancillary products such as hemp, alternative products, we're talking about cookbooks, that kind of stuff. It takes time to organize this stuff, requiring a business loan, financing. My question is, come March 1st, or whenever you guys start issuing our pre-approval, if we already have a storefront that we've put money down on since June of last year, what's going to stop somebody else from getting in there, first come, first serve, getting in front of us and saying, well, we got the permit before you, but we've already been set up, planned for this. You know, this isn't something where February comes and then, oh, I guess I better find some pot. You know, like, we need protection from you guys saying that if we're setting up right now, come March, we're not going to get outed by some dude who's like, oh, cool, I got a ton of money all over the dispensary.
Right.
No, your point's well taken, and I've heard that from a number of dispensaries. We're going to have to define that.
Okay, quick time.
Oh, go ahead.
Okay. Non-Oregon green card holders, what about people coming through vacation? Lots of Cali, we're right in the middle of Washington and Cali. Colorado's a couple of states over. What's gonna happen when someone wants to come and say, I'm here for vacation, I need my medicine? You know, is that gonna be something approved for them to take back across state lines? What about outsourcing our product to like a bakery who we provide the butter? They're gonna bake us gourmet cupcakes, gourmet edibles, that kind of stuff. Do they have to have a dispensary license, or is that something where they can just have a green card? We provide the product, it's guaranteed. We bring this, that, they're bringing us brownies. It's measured, accounted for, how much each THC is in there. Those questions that not even covered in this, and I think needs to be paid attention to.
Great. Thank you. John Seho, and followed by Jeremy Sackett.
Hey, Tom, can I make a real quick comment? Not on the last 2 points. I think his last 2 points are legitimate, need to be addressed. Unfortunately, I think they're beyond the purview because they're not covered by the law. Another couple of points that may need to get addressed. His first point was really intriguing because he basically says, I'm operating a dispensary, I want to essentially be grandfathered in, and I'll have somebody ace me out of my 1,000 feet. I get it. It makes perfect sense to me. I don't know how we address that in the rules, but that's one of the issues. A corollary to that issue is the enforcement piece. What happens after March 1st with what then will be the rogue dispensaries that decides to tell all of us, I ain't playing ball? What do we do? If we don't do something, why would anybody bother to get a dispensary license? And that's the corollary to it. We need to address that issue as well.
It's not an OHA issue, that's a law enforcement issue, and for you to bring cases. No, I mean that's a very, I get it, but other than a true public health authority, where we go in and quarantine people and close down places.
Well, except keep in mind, Gary runs a division of the state. If we had a pharmacy that decided, I won't name one of the big shops, because it wouldn't be a big shop, mom and pop pharmacy said, you know what, heck with you. I ain't doing any of that stuff. I'm just running my rogue pharmacy. Nah. It may be a law enforcement issue, but it's also a huge administrative issue, and he'd be talking to Shannon, and she'd be shutting them down. She'd be filing an injunction and close them down tomorrow.
Isn't that part of our enforcement? I mean, that seems like we're going to need to put that in there.
I think we are.
Anything that's rogue has to be stopped, or it's going to affect everyone else that's being legit.
And I think we need to have rules to address that. It's not just turn it over to your local sheriff or DA, because I think we need an administrative process to deal with it.
I think it's going to be both.
Both. So that's an area of the rules that I saw was missing. I forgot to mention earlier, sorry.
Jerry? Yes, my name is Jerry Norton, and I'm representing BioTrack THC. We are a seed-to-sale solution. We're currently working in Colorado and Washington at this time in over 200 locations. BioTrack THC would address Bill 3640 PP and QQ of the Oregon Health Authority's new rules and regulations, which basically we are unlike any other POS system. BioTrack resides on their own server, and you can rest assured that no one, not even the BioTrack team ourselves, can access the important, valuable information that's privately held and customer information without their permission. So we are the company that does not use a cloud-based system. Basically, we're a cutting-edge technology firm that is doing everything from seed to sale. So we do everything from state revenue reports to Department of Revenue reports for the state. BioTrack's fully compliant with all marijuana state local regulations, including Canada. BioTrack's currently generates over 100 meaningful reports for the dispensaries. So referencing Bill 3460 PP and QQ for the Oregon Health Authority, we believe our company has a solution for tracking from seed to sale every product that's shipped to Oregon.
Great, thanks. John Seho. Jeremy Sackett, should I?
Thank you very much.
My name is John Sejo. I'm the director of Voter Tower, and I've been working on
writing medical marijuana rules for a long time. I was a co-author of Measure 33 and Measure 74. I have a number of observations I want to throw out real quickly. One is that one of our goals here is to create a safe, reliable, consistent supply of medicine for the patients, and it's inherently difficult requiring a system that depends on thousands of small growers. Among all the growers out there, there's a wide range of quality that they produce, from fabulous medicine to terrible medicine, and I think we're going to face a situation where a grower may produce great marijuana, or looking to the future, products are going to be developed that we haven't even imagined yet. Say some grower produces a topical ointment that can be applied on the skin, but they're limited to the 24 plants they can grow. They're only going to be able to make a little bit of it. So if somebody produces an excellent product, there's no way under this current system to make that widely available to everybody. And I hope that as we move forward, we can find a way around that, whether it's growers working together. And I really think Todd and a lot of this discussion has hit on it. In the long run, we need to regulate the production and allow growers to have larger limits, so whoever makes the best medicine can make a lot of it and not just a little bit. Another issue I just want to bring up, because people have asked me to do so, is that in some of our initiatives we have assistance for low-income patients. A lot of patients, are because they're sick, are very poor, and they can't use Medicaid or health insurance or any of the traditional things that ameliorate their situation. So how can we work into this system, helping the poorest, neediest patients, and not creating a system where we put on so many rules that it makes the medicine more and more expensive and puts it out of their reach. So let's not forget that. I have a question about it seems to me that 3460 basically requires dispensaries to be nonprofit without requiring them to be a nonprofit. And I'm curious about how that particular thing is going to play out. I've talked to some attorneys about it, for example, and another sort of related question I have regarding the grower is, under the new law, now a grower will be able to be reimbursed for all expenses, and that includes labor and lots of other things. My reading of that is that the grower would now be able to hire somebody to help them, and that person would be an employee. And how about the taxes on that? The lawyer I talked to said that clearly that the taxes paid to the grower's employee, that would be a legitimate expense, and that employee could pay income tax just like anybody else. But that attorney told me that because the language says reimbursement, that the grower paying taxes would be complicated because you can't pay taxes on reimbursement. And it's already over my head, but I hope you all will give us some guidance on that, because there's a lot of issues surrounding that. Another question that has come up is farmers markets. They exist in Washington. They're very popular with patients. My reading of the law is that they would be possible somehow if growers came in, and we're doing it under the auspices of a MMF, but one way or another, please make that clear. Another general thing I'd like to raise is that we're anticipating a system here that's tracking all the purchases of medicine going in and out, and presumably red flagging patients, for example, that would come back many times a day and buy something, because then it looks like they're probably diverting it. I'm wondering, are there going to be mechanisms like that? How is that going to be addressed if we're tracking medicine purchases? And I guess I understand that there might be interested in that tracking for law enforcement purposes, but I would also ask that we consider tracking for scientific purposes, since we are in an era now with Simpson oil and DHO and all sorts of new products. This is just really a hotbed of innovation and development. Is there some way that we can use the tracking system to put on an overlay of epidemiological research, so we're not just watching how much patients are buying, but we're seeing if it works, and so that we can eventually move to a system where we're finding out what about these claims about Rick Simpson oil? How can we verify them and use the tracking for that purpose? Thank you.
Great, thanks, John. Jeremy Sackett. Okay. Followed by Kirsten Gustafson.
Good
morning. My name is Jeremy Sackett. I would like to present recommendations on the quality control testing aspects of the House bill. This is based on my experiences in analytical chemist and FDA-regulated drug development and manufacturing, and over the last 2 years of launching and operating a botanical analysis laboratory and research facility in Bend, Oregon. I've documented, in conserving time, I've documented the recommendations in a memo that I'd like to distribute to each committee member. They're based on 2 priorities, which are patient safety and the efficacy in producing a quality product to bring to market. Acknowledging that there's no GMP regulation for the growers or the processors at this point in the statute, we have to consider that the facilities and the laboratory testing is the final stop gate in providing, a safe and quality product to the patients. In closing, I'd just like to freely offer any service that the committee would request of me for my skill set that I could be of service and assistant. Thank you.
Thank you.
And you can distribute these?
Yeah. And we'll upload these on the web so everybody can see them.
Hi, I'm Kristen Gustafson. Thank you all for your time and expertise on this. It's already been said, it's going to make a big difference to all of us. I want to clarify about concentrates. We're talking about Rick Simpson oil. Rick Simpson oil is actually a brand name. And, excuse me, one thing that differentiates that from what I'm going to call full extract cannabis oil is that Rick Simpson oil does not use food-grade solvents. They use isopropyl alcohol or they use naphtha. Whereas the full extract of cannabis, the other one, I'm sorry, I'm trying to go fast. When we use food grade, and it's not Rick Simpson oil, and so maybe we can change our terminology and also understand that there is a difference between using food grade and not. I'm not a pharmacist or a chemist, so maybe these solvents are acceptable for medical applications, maybe they're not. But food grade, we're pretty sure is okay. So that's pretty much all I have to say about that. We haven't talked about organic certification. I'd like you to consider that. That's very important for some patients because it's medicine. And we haven't brought up topicals. What kinds of standards or processes are we going to expect for topicals? That's it. Thank you very much.
Thank you. Kyle Hager, followed by Matt Wallstatter.
My name is Kyle Hager, and I'm interested in clarifying some of these concentrates, and I'm going to give actual numbers on something that took place less than 3 days ago. I took 28 grams of regular pulp, I call it pulp, of just regular product, and then I keefed it, which reduced it from 28 to 1 gram. So here's 28 parts of stuff that may be burned with carbon monoxide and all kinds of stuff that is not needed in my particular medicine. And every strain varies a little bit. And then I took that keef product that was reduced from 28 to 1, and I went and took that and made it into oil. And some of these oils in the hashes are made with ice water. That's how bubble hash is made, ice water. And so then I reduced that keef from 28 to 1 to 4 to 1. So now I've reduced from 100 to 1. So if this is ounces, this is 100 ounces that was going into my system with all different kinds of chemicals reduced down to 1. And that is a huge number. Everything's concentrates, all pills are concentrates, alcohol's concentrates, foods are concentrated, everything is concentrates. Concentrates are not the enemy. They're actually safe to get rid of all these products that I don't need. Now those are my numbers and what I was after, and some people will be after hemp, some people will be after cannabinoids with no THC in them at all. And so these concentrates are huge because that 100 to 1 that I got rid of, I don't want them in my system. I don't want to smoke them. I don't want to eat them. I don't want them near me. I'm after this 1%. That's 100 to 1. Thank you.
Thank you. Matt, followed by, it looks like Nicole Salek and Jim Vermeer.
Thank you. I wanted to address the 1,000 feet from the school requirement, and specifically, it was my understanding that the intention was not to include preschools, but the language in the statute, the 1,000 feet from the premises of a primary or secondary school, primarily attended by minors, comes directly from the criminal law. And there are case law in the criminal courts saying that, I think one was a Montessori in the basement of a church that was unadvertised, delivery within 1,000 feet of that would qualify. So my question is, if the intention is to exclude preschools, is that something that can be handled in the rulemaking process here, or at least clarified one way or another? The second thing is with regard to transfers, and I realize that there's a strong priority to protect patients, and that we need to do that. I think that whatever we find, there has to be some measure of certainty, so that a shop owner, a facility owner will know that when they take meds from a patient, from a grower on behalf of a patient, that they own that or they don't. And I think there's a long history in our nation of property law and contract law, that's developed over hundreds of years to address that. So I think that we'd be well advised to take that in mind and allow people to transfer their property in the way that they choose to, and then allow people to make contracts to determine how that property is going to be transferred. Thank you.
Thanks, Matt. Nicole?
I wanted to address a little bit the testing issue again. I know it's coming up because it's really important. There's several different compounds in there that people are looking for, and some are looking for pain relief, some are looking for other issues. So in the testing process, you're only asking, for pesticides, molds, and mildew, but I think % of active ingredients would be really important. And in my own experience as a patient and dealing with my own medical providers, because that's their main hesitancy in prescribing or recommending it, is that the variety of strength changes so much from plant to plant, from product to product, that they have a hard time coming up with a standardized dosage. So if we know exactly what's in the medicine and provide that information to the patient, that helps them get a more accurate dosage for their need. In addition, that should be applied to the concentrates as well. Your point, Paul, that you were saying about concentrates, being more attractive to people that are thieves, but I think that those security issues that you guys are going to address are really important, because we don't ask pharmacies not to carry methadone because people might steal it. People need it. So as far as that goes, and you could also include, because I'm a fan of the food grade extracts myself, but people are making the other types of extracts, so in the labeling, being clear about what the extract is, and possibly testing for those in the testing process, so people know what the leftover, whatever was left over in the butane or whatever, they know exactly what the contaminants are in there before they take it.
Thank you. I'm going to go in a different direction. Jim Thamir. Sorry.
I'm a little bit concerned about the application process, that if it's first come, first served, first in, that we'll receive some sort of a number like you do at the DMV. You've already got in there, your number came in. So because the application process might fail for some of us or be rejected, I'm a little dubious about the way it's written now, or proposed, that we get sent to the back of the line and then never get back in the line because we dropped the ball, didn't get something filled out. And electronic filing could be very problematic for all the things that have to be submitted, but I suppose a lawyer could be hired for that. Thank you.
Great, thank you. Kelly, you've been asked to come and comment. Rep. Buckley has sent us a text asking you to come down and comment. While Kelly's coming down, Sam Simmons and Lauren Kersey.
Kind of nervous to talk in front of everyone. Things that haven't been addressed. Medical marijuana, medical. So at the end of the day, it's a medicine. We were drawing all these similarities to pharmacies. When you go to a pharmacy, they don't say, yeah, bro, this is gonna make you feel really good. They have a language, and they tell you, like, it's gonna make you nauseous, or it's gonna make you this, you can do this or that. I think that if we had a way to have a mandatory class for all dispensaries, where we had a common language so that we could kind of get everybody on the same page. So when a patient comes in, they can expect to hear the same terminology from one place to the next, would be beneficial to them. I'd love to see a grower represented on this committee, while you all have like very finite amounts of knowledge. I don't know, or if you would want to say if any one of you actually grows. And is so if you have somebody representing that could tell you the pitfalls of, oh man, this is what bugs are like, this is electricity loss, this is this obstacle I ran into, and that might kind of help what you guys are doing in a more real life or real time way. And one last thing is the 1,000-foot rule. To me, not that I'm going to open a dispensary, but if you set that up, like the gentleman said before, it takes a lot of time. So it's almost encouraging you to set one up now, stake your claim, get it running, run it legally, and then apply for your application. Because then you're already there and you're established. Because just like it was said earlier, if you apply for that application and you get it, whoa, what do I got to do? I got to stock the place, I got to do all the setup, and obviously you don't want to sign a lease to a place that you can't feasibly use if you get denied your application. Thanks.
Kelly?
Oh, I forgot to mention it earlier. I'm a horticultural scientist specializing in cannabis. So
Good afternoon. My name is Kelly Manning. I'm the Development Services Director. Speak up a little bit, Kelly. Sorry about that. I'm the Development Services Director with Jackson County. And I've been in communication with Representative Buckley about this bill and how it relates to land use. I'm happy to hear from Tom that there is going to be a local government kind of subcommittee that I'd like to participate on, talk about the land use issues, the land use process, and business license process as well. I think that that is a very critical part of this licensing that you're talking about, because basically what the bill says is to qualify for registration under the section, the medical marijuana facility must be located in an area that has a zoning designation. And I think the zoning designations that have been used in an urban context are understandable, but from the county's perspective, when you use the term agricultural land, which I would not probably have recommended if I had been asked when this bill was crafted, is a little nebulous. It's not a zoning designation. The zoning designation related to agricultural land is exclusive farm use in state land use law. So I think there needs to be some discussion about what that means. I know that the legislative intent was not to allow these on residential land, and yet we have agricultural land or agricultural uses that are allowed in rural residential lands, for example, in Jackson County. So, and not just in Jackson County, but in counties in Oregon. So I, like I said, encourage the subcommittee to local government to talk about some of these issues. I think that's all. Unless you have any questions for me.
Great, thanks, Kelly. Lauren, did I get you up here? No? Who did I call? Sam? Who are you?
I'm Lauren.
Oh, you're Lauren. Okay, come on up. You looked at me like I was crazy, and I couldn't. I'd lost track of where I was on my list. I'm sorry.
Hello. Thank you for coming today. I have some quick questions here, and maybe you can explain it, and I'll move on. But are we not being able to buy the medicine at our dispensaries? Because I hear all this twisted information about how we're going to reimburse and who incurs what costs, but really, aren't we doing the business of taking product in and then disseminating it and giving out to other people? So I'm just really confused, because when you have costs such as testing, I made some calls about testing, and the minimal cost to get it tested is about $115 per sample. So you're looking at a pretty good deal of money for every lot or every sample that you have. So in that way, I mean, you're going to want to bring in, me as a businessman, want to bring in 1 pound compared to 1 ounce. So if you're a small grower and you're only producing 2 or 3 ounces in your indoor grow, I wouldn't look at taking that into my business, because it wouldn't be cost effective for me to do that, because it's going to cost me $115 to get it tested. So who incurs that testing cost? I believe that that the dispensaries should be doing that, and that's on their property at that point. Perhaps, you know, some kind of containment thing, I'm not sure. In regards to the organic versus safe, I disagree with you. I believe that there's two different pieces here. There's an organic product that you're more than entitled to go and buy anytime you want to. If you want an organic peach, go buy it. My personal belief is that whether or not the medicine is safe and whether it's been documented as being safe by a lab. In regards to safe access, I believe there's 3 areas that need to be addressed. We need a dispensary, we need a nursery, and we need an idea of the producers of the topicals and edibles that are out there. There's 3 different areas there. I've always believed in, just like my mother taught me, that you can either give a man a fish or you can teach them to fish. And as a nursery, you should be able to do that. You should be able to grow plants and get those out to people and get them connected to their own medicine that way. Anybody that's ever grown an indoor crop though can tell you that it's not easy work. We have a large farm and we maintain outdoor, and it's a ton of work. So those 3 areas is what I see that we need to look at. I'm especially interested in the nursery side of it. That's where my heart lies. And so again, now we're talking about registrations. We're looking at multiple locations. If I have a corporation and I want to open up in Salem, Bend, McMinnville, or Corvallis, so am I going to have to buy a registration for, pay a fee for each one of my locations? What if I have a mobile dispensary? What if I want to have a mobile vehicle that goes out to these nursing homes and care facilities? Is that particular vehicle going to have to be now registered also? There's some questions I have about that. In regards to security, excuse me, Mr. Director, Gary? Is that all right? Yep. Do you have to lock up your Viagra and not yours personally, but Michael, each pharmacy have to lock up their Viagra? I'm sorry, I'm 51 now too, so. You have to lock up your Vicodin and your Viagra and all this every night when the pharmacy closes? I mean, is there like a big safe that everybody grabs everything off the shelves and puts it into?
No, the room has to be locked.
Okay, so that's what I'm saying right now, is that our goal when we get started is to create containment rooms where our security starts at the very outside of the house, moves inward, includes all the components that's here. So maybe we look at maybe the room itself is the safe. I don't know if that makes sense or not, but, all right.
Okay, in the interest of time.
All right, thank you.
I've got one last person who is it Pete? I have an MTV.
Anthony, can you speak for me, please?
I know that PK is always interested in keeping the patients foremost in this discussion, and is also interested in making sure that the growers are protected as well as the facilities.
Great, thank you. Okay, thank you all. I appreciate it. I appreciate the committee. We'll start changing emails. We'll do a survey for meeting dates and locations. For those of you in the audience, watch the webpage. Any notification that comes from that webpage, it may change over time. So just be sensitive and make sure you stay current on the webpage. Thank you.
I'm going to run out and grab some of the folks. Do you want to say anything before I turn it off, Glenn?
Yes, good night.
Good night. God bless you all, every single one of you.